Affidavit has been filed, your lordship.
In fact, they have this
Hard copy has been.
today. They have given me the affidavit just 10 minutes back. But we have also given a convenience note.
Convenience note last. Just now I have received the convenience note also.
Affidavit, I have been able to see some of the portions. These first issue would be overcrowding. If my lords would see, these are the figures of
Jajpur.
Jajpur. These are 2/3/2023. So collected by the state legal services. Jajpur is an issue which has been going for quite a long time. And here the land issue needs to be expedited. They have not been able to select land for Jajpur also. That's a part of their affidavit also. Malkangiri also expansion needs to be expedited because that wall.
Actually, Malkangiri is the opposite. It's gone up, the overcrowding.
My lords, as regards Jajpur is concerned, our reply is at page 2.
No, that's right. Jajpur, you've reduced it to
48% and from 77%.
Correct. Now, if you look at Malkangiri, for a E, page 4.
Page 4.
Sub-jail Malkangiri, it was earlier 37% overcrowding. It has gone up.
A slight increase.
Yeah, it has gone up. So, how is that possible? Mr. Chabra?
Yes, Mr. Chabra is there.
We have to unmute, sir.
Sir, good morning, sir.
Good morning, Mr. Chabra.
Good morning, sir.
This is your affidavit that
Sir.
internal page 4.
Sir.
This Malkangiri, sub-jail Malkangiri,
Sir.
the overcrowding has gone up.
Sir, it is actually a function of the police cases which are filed, lot of those ganja cases, etc. So the crowding is a constant issue, and hopefully we'll be able to resolve it once this compound wall is constructed. The work is going at good pace, sir.
Okay.
And the Housing Corporation can actually tell me the exact dates, but I assume I have been in touch with my jailers and other staff. They have been telling me that probably by middle of next month, the thing will be completed. They had initially promised 4 months, but it will be done before that.
All right. And what happened at the Prison Development Board meeting?
Prison Development Board meeting was held, sir. In fact, it was quite a feat for us to have because the new chief secretary had just joined and we could get him to do the meeting. So meeting has been done, sir.
Okay.
And some new developments have taken place, which I'll come, sir, once the issue is raised, sir.
Page 27, Annexure C.
Yes, Mr. Mishra.
Yes, my lords, may kindly see overcrowding. I have just skipped that portion I have read.
Right.
Jajpur, what I am told by the government is that now the issue of selection of land has hit some kind of a roadblock. So if there some timelines can be fixed, the collector can acquire the land and give advance possession. That's what their affidavit says. If my lords would see their affidavit, they say that there's a request and the collector, now the ball is in the collector's court. So if some timelines can be fixed for this new site land acquisition.
Site for new sub-jail.
At page 3. So earlier, if my lord
So
would
they've identified the land. So this we need to give advance possession.
Yes.
So the land has been identified and we have requested the collector to give us advance possession so that we can immediately hand it over to Housing Corporation. The funds are also available. So as soon as we get the land or a letter from collector that we grant you advance possession, which is a technicality. So it is now with the collector. I am assured by their staff that it will be done quickly. But the past experience has been that in the past, about twice the land which was selected was cancelled at the last minute. So till the time we get it from the collector physically, that's the issue, sir, still.
All right.
I think this is the second or third attempt in getting land in Jajpur. Malkangiri, that compound wall was an issue earlier.
That's what he just told us.
Yes, that is.
Point number D is something which is, according to me, it's something serious. Point number D at page 3 of my convenience note. Roughly about 45 to 50 prisoners are there who have not been able to come out because of non-furnishing of bail bonds. So I've given the details. Also, these reports are a part of the convenience report. All these DLSs in their reports have actually given these figures.
Okay. So what can the DLSs not go before the magistrate and...
they have been trying, but if a general direction is given to the member secretary, he can take it up on a priority basis.
Right. But there'll be 3-4 districts.
My lords, there are several districts.
Yeah, 7 districts. All right.
And my lord knows that that judgment of where I have given that Motiram, where Honorable Justice Krishna, he had made it clear actually that this going out on bail on surety is something which is a misnomer. These people, if
PR bonds, they call it PR bonds.
PR bonds. So that should be encouraged. If somebody is not able to...
Even more recent judgment of the Supreme Court, which reiterates this.
My lords. In fact, Justice Krishna had said that poverty is something which is not linked to fleeing from justice. So those paragraphs I have mentioned here, the judgment also is a part of the convenience note. My lord wants, I'll quickly run through those paragraphs.
No, actually, there is a more recent judgment.
My lords.
Justice Sanjay Kaul's bench.
My lords.
And they have been actually, because we get this on the administrative side.
My lords.
They've sent it to all the high courts. There's a very, very recent recent judgment, just I think a few months ago.
My lords. SK until is also there and other judgments. I'll give those judgments.
Then mental health.
Mental health is something which is... they have to look into that. In this context, my lords may kindly see page 11 of their affidavit, where these two services they have started, but that needs to be actually encouraged because Telemanas and e-Sanjeevani, those facilities are there, but none of the prisoners are availing it. So that is something which Mr. Chabra and his team can...
Yes, Mr. Chabra, tell us about this.
Yes, sir. So mental health, there has been improvement, sir. Slow improvement. There are various aspects. I'll outline one by one, sir. So as far as Telemanas facility and e-Sanjeevani facility is there. So after a little initial hesitation and lack of sort of knowledge about it, now and awareness about it, now the jails have started using it. In the last month itself, we have used it about 70 times. As far as the facilities of e-Sanjeevani and Telemanas is concerned, we need to use it much more, and we are constantly sort of making them aware in collaboration with the health departments. Secondly, sir, about training of the medical officers of the jails about mental health issues, we have already coordinated with health department, and in collaboration, they have already conducted one such training for all our medical officer on 6th of March itself.
Okay.
And further trainings are being proposed, and it will be carried out as a matter of routine now. Thirdly, about psychiatric social worker and clinical psychologists, we have already got the clearance from the government, and we are now in the process of issuing an advertisement, which will be issued either today or tomorrow. And after the issue of the advertisement, within next about 15-20 days, we should be able to recruit some number of psychiatric social workers and clinical psychologists, so that they will be able to join and do the therapy work and counseling work in the jails. So this is as far as the progress on mental health issues is concerned.
Right. Yes.
Rest, I think health department, health secretary is also there. If any other further information is required, I think we can.
Namaskar, sir.
Namaskar, Ms. Pandit.
As has been already detailed by Home Department, the e-Sanjeevani and Telemanas services have started picking up in the last 2 months, particularly the e-Sanjeevani. 75 sessions have been had been scheduled in January and February. The jail visits have been going on in the month of January alone. 124 jail visits have been done by our mental health specialists to 88 jails. And the services being provided are both on mental health as well as on de-addiction.
All right.
Recruitment against vacancies of jail medical officers is ongoing through the Odisha Public Service Commission, and we are expecting that in the month of May, the 24 vacancies that remain, they will be filled up, and so we will be in a better position at that time. Thank you, sir.
All right.
So next point, I think the deadline of May to 2023, that can be considered. Then this emergency response facility regarding these ambulances, 20 they have. Now, my lord knows there are about 87 jails. So here, if some more can be provided, this is actually caught in a logjam between the government. Some of the prisons which have a very high population, there at least there should be one vehicle available.
What's the position on that, Mr. Chabra?
Sir, we got 20 ambulances as in pursuance of the directions of the Honorable High Court, sir. So those 20 have been provided to the highest population prisons. And we had requested 20 more in this last PDB meeting also.
Okay.
The government response has been that they have assured that an ambulance will be provided on priority basis to the jail. And a joint circular by the Home Department and the Health Department will be issued. This was decided in the last PDB meeting. I have included that minutes. So we are assured that the ambulances which will be available as and when required. So I am hopeful that these things will come through, and we have to see for the future. If it happens, then our problem is solved. If not, then we can take it further, sir.
So these 20 more would be on a shared basis. That's what I understand. So instead of them being exclusively given to the prisons department, they will share it with others. So here, if I can request, if the government can be kind enough to add some more.
That
maybe
at
15
page 28, your lordship may see page 28 of our affidavit. That is the agenda number 4. Provision for 20 more ambulances of emergency service response. That is one of the discussion and minutes of the meeting.
So this would be, if my lord would see that 108 is this normal ambulance which
that's right, the usual.
So they are saying that those will cater to the prisons. I think this, of course, in smaller jails, this is okay.
20 more.
20 more won't be provided.
Proposal for supply of 20 more ambulances for emergency response was...
Actually, the response is something else. The response is not saying we will provide. It simply says that 108 number, if you call, then on priority basis, it will be shared. It will be sent to the prison. On priority
108 ambulance, everywhere it is available. So on priority basis...
Actually, I'm not having a clear idea. Mr. Chabra,
sir,
like, let's take up the Malkangiri sub-jail.
Sir,
would it have an ambulance?
Malkangiri already has an ambulance, sir. We have provided in the first 20 itself, because it had a high population.
Correct, correct. That's why.
Presently, sir, the 20, the highest population prisons have already been provided.
Okay.
And another 4 or 5 were having earlier also. So about 25 prisons already have the ambulances.
But there are 87 prisons.
There are 87 prisons.
So that's why.
So some of them actually have a very less population also. Some are overcrowded, but some have very little population. So actually, sir, once the government has given us this assurance that not only 108 ambulances, but also ambulances available with CHC are available, and this was assured that a joint circular will be issued shortly. You can actually see the proceedings, sir. A joint circular by Home Department and Health Department will be issued that on priority basis prison will get. So as long as we get the ambulance when we require,
right?
I cannot actually say that I want anything more, but that remains to be seen, sir, in future.
All right.
Then, my lords, may kindly see this corpus fund restructuring and prison modernization. There, two have been cleared. So far as prison modernization and restructuring, I think that's also caught in a logjam. I think restructuring is something which Mr. Chabra would be able to say. This needs to be expedited. Corpus funds, they have said. So far as restructuring, I think it's caught up.
Sir, I can give an I can give an update, sir. There were three proposals. If you, my lordship, will recall, sir. There were three proposals basically which were to be cleared by the Home Department. The instructions were given that this should be cleared by 1st March. So corpus fund is one for which we have been informed by the government that already budget provision has been made. That means the corpus fund has been created. But we will only get it once the budget gets passed. So this is just a matter of technicality. So that problem or that issue stands resolved. Secondly was about prison modernization scheme. That also the government has made budget provision. So as soon as the budget is passed, which will be shortly, we will get that money and the work will start on the projects. The third one is the restructuring of prison, which will involve giving us more manpower in various ranks like warder and assistant jailers. So that is in the final stages. There were some queries by Home Department. We have been meeting and it's a kind of ongoing kind of consultation. So they are in the final stages of preparation of that proposal. So that I hope, and I'm quite hopeful that that will also get cleared.
All right. There is some DLSA report.
Some of them, I have given the ones which are relevant. Now here, my lords, may kindly see a general direction may be passed to complete another round of inspections because that thing is something which really helps in checking the food and all. Then, my lords, so far as DLSA Khorda, if my lords would see, that is at page 51 of the compilation. It's regarding one of the premature release of one of the convicts. If a direction can be passed for this, because if the proposal has been pending with the government, the letters have also been mentioned at page 53, last portion.
Yes.
Similarly, there is one more issue which is somewhat serious at Angul. That, my lords, would find at page 54, the report of the DLSA begins, and the relevant portion is at page 56. Angul, my lord knows, is also known for its NDPS cases. So that's what is coming out from the report also.
All right.
This is somewhat serious. At page 56, that portion is there.
Mr. Chabra, I think a copy of this note, I don't know if you already have it.
Sir, I just received it today morning, but I only received the first 8 pages. Yes. I haven't received the full report.
I see.
So anyway, I will go through it and we will take necessary action, sir. Definitely, it's a serious matter as it seems.
Right.
And some CCTV issues is also there. I would like to inform also, sir, that CCTVs in many jails were actually becoming redundant because they are very old. So this year, out of our funds, we have procured a large number of CCTV cameras, which are now in the process of being acquired. So in the coming time, few months, our CCTV coverage, etc., will become much better, sir.
All right. That's it.
Well, it's just one. My lords, since my lords had referred to Justice Call's order, if I may, my lords just pointed out. My lords, the case is, my lords, in policy for grant of bail. So in fact, on the last occasion, they have passed certain modification, certain directions with modifications. One of which is that if the bail bonds are not furnished within 1 month from the date of grant of bail, the concerned court may suo motu take up the case and consider whether the conditions of bail require modification or relaxation.
Exactly.
That, my lords, could be.
What is that date of that judgment and order and number?
is that the date of the order is 31st of January 2023. My lords, I'll give a copy. 31st of January 2023. This is suo motu writ petition criminal number 4 of 2021.
All right. You see, an affidavit has been filed. An affidavit dated 6th March 2023 has been filed by Sri Shubhakant Mishra, Deputy Inspector General of Prisons, dealing with the issues highlighted in the order dated 9 January 2023 passed by this court. This court has also had the benefit of the online participation of Mr. Chabra, the DG of Prisons, and Ms. Pandit, the Additional Chief Secretary Health. So this court has also heard the submissions of Mr. Gautam Mishra and Amicus Curiae and Mr. Devakant Manj and Mr. Ishwar Manti, Additional Standing Counsel for the State. Then you put the subheading as overcrowding of prisons. The affidavit of the Prisons Department indicates that in Jajpur sub-jail, the extent of overcrowding has been reduced from 77% to 48% as of 22nd February 2023, with the shifting of some of the prisoners. To the nearby jails. As regards the site for a new sub-jail in Jajpur, Mr. Chabra informs the court that land to an extent of 20 acres has been identified, and the collector and district magistrate Jajpur has been requested to alienate said land in favor of the Home Jails Department and to hand over advanced possession thereof, so that the construction of a new building for the sub-jail in Jajpur can commence. Paragraph. A direction is issued to the collector and DM Jajpur to take the necessary steps for alienating the said land in favor of the Home Jails Department and hand over advanced possession. These steps be concluded by May 2023. The court takes note of the reduction of the overcrowding percentage in most sub-jails except the sub-jail Malkangiri, where it has gone up from 37 to 45%. Mr. Chabra has explained that the construction of the boundary wall of the new sub-jail at Malkangiri is in progress and is expected to be completed by, shall we say, end April?
Yes, sir. Yes, sir. Definitely.
By end April 2023. The court takes note of the above submission. And expects that as a result, the overcrowding in the Malkangiri sub-jail should reduce considerably by the next date. Then, next subheading, you say furnishing of bail bonds by prisoners. The note of the Amicus Curiae points out that from the report submitted by the District Legal Services Authorities, DLSAs, there are several prisoners. There are as many as about 22.
No, some of them are not numbers, and so about 45 would be the number.
There are almost 45 prisoners who are unable to exit from the respective prisons on bail because of the inability to furnish the bail bonds. The details of 22 such prisoners has been set out in the note submitted by the learned amicus curiae. Full stop. The court reiterates the directions already issued by the Supreme Court in Motiram versus State of Madhya Pradesh, 1978, 4 SCC 47, and the recent order dated
31st of January 2023.
31st January 2023 of the Supreme Court of India in
SMWP criminal number 4 of 2021. SM, that is suo motu writ petition.
Suo motu writ petition criminal
number 4 of 2021.
4 of 2020.
21.
4 of 2021. Mr. Chabra, you must be having copies of those. Copies
Sir,
of
I've got in the convenience note.
All right. Copies of the said order should be made available to all the DLSs, if not already done. We'll stop. The secretaries of the DLSs of Kalahandi, Kandamal, Baleshwar, Bargad, Jharsuguda, Sambalpur, Kyonjar, Navrangpur shall take immediate steps to file appropriate applications in the court of the respective criminal courts to facilitate the early release of such prisoners by modification of the bail orders passed to bring it in line with the directions of the Supreme Court in the above two cases. So these steps positively be completed by 10th April 2023. Full stop. The Secretary, State Legal Services, Orissa State Legal Services Authority is requested to coordinate with the secretaries of the DLSs, aforementioned DLSs, so that these steps can be taken in a time-bound manner and completed by the 10th of April 2023. Stop. A compliance report be placed before the court by the Secretary, Orissa State Legal Services Authority by the next date. Then third, is submitting mental health prisoners. As regards filling up the posts of psychiatric specialists and clinical psychologists, Mr. Chabra informs the court that advertisements will be issued very soon for recruitment.
Sir, if I may, it is psychiatric social worker, not psychiatrist.
Okay. I see. Then for the posts of psychiatric social workers, bracket PSW, he says advertisements will be issued very soon for filling up of such posts. Full stop. The court has been shown the statistics of the visits made by doctors, psychiatrists, and psychologists in the months of January and February 2023 to the various jails and sub-jails under the scheme of Telemanas and e-Sanjeevani. That's Telemanas and e-Sanjeevani is apart from the visits, right?
Yes, sir.
Yes.
All right. Visits as well as the services provided under the Telemanas and e-Sanjeevani schemes. Full stop. Ms. Pandit, you were talking of the posts of psychiatrists and psychologists.
It's a jail medical officer, sir. 24 vacancies expected to be filled up in May.
All right. Ms. Pandit informs the court that the vacancies in the posts of jail medical officers are expected to be filled up by end of May 2023. So an updated status report in this regard be placed on record by the next date. Then you say emergency response facility. As regards the provision of ambulance services, The court notes that this was discussed in the meeting of the Prison Development Board Committee held on 3rd March 2023, where it was decided that apart from the ambulance services available on dialing 108, it was decided that the ambulance available with the nearest, this is community health center, right?
My lords. There, my lords, may I suggest that at least 10 more if they can get, there's some problem there. So,
20 minutes.
Will be shared on priority basis with the nearest, with the concerned jails for shifting of prisoners in need of emergency health care. Paragraph. The court notes that 20 ambulances have been provided, which have been already allocated to the most crowded jails and sub-jails. Full stop. At least 10 more be provided by the health department, right?
Yes.
by the home.
Ms. Pandit, it's the health department will provide the ambulances?
Yes,
No,
madam.
sir. The health department will provide ambulances to the 108 fleet. Outside of that, we do not provide, sir.
No, but then
Sir,
who?
if I may, sir, the last 20 were provided through the home department.
Through
Once
home
the
department.
PDB decision was there, and it was on outsourcing basis. They didn't
I see.
purchase this thing. It was cleared on outsourcing basis.
Okay.
Given the huge number of jails, at least 10
Yeah,
more
this
would
is considering that there are 87 jails and sub-jails in Orissa, and direction is issued to the Home Department to ensure that at least 10 more ambulances are provided to the Prisons Department for use in the jails and sub-jails. This be done by the end of May 2023. Paragraph. The note of the amicus curiae, then you just say reports of DLSA. The note of the amicus curiae highlights the reports received from two DLSAs, that is Khurda and Angul. Full stop. The report of the DLSA Khurda refers to a pending application concerning the premature release of one convict, which has been pending for the last since 23rd July 2021. Full stop. The Additional Chief Secretary Home is directed to have the said proposal examined and a decision conveyed thereon not later than 31st May 2023. Paragraph. The report of the DLSA Angul highlights the complaint of one of the inmates stating that he's being assaulted and tortured by another convict and certain UTPs. In the Talsher, it's a sub-jail or jail? Sub-jail. Mr. Chabra, who has a copy of the note of the amicus curiae, states that he will have this immediately examined and corrective action taken within the next week.
Special subject.
Special subject, all right. On the next date, the action taken on these two reports of the DLSAs of Khurda and Angul shall be placed before the court. Paragraph. As regards the allocation of funds for an allocation of a corpus fund of the PDB as well as funds for prison modernization, Mr. Chabra informs the court that provision has been made in the annual budget for 2023-24. And it is expected that the funds will be released soon. Full stop. The court will be informed on the next date of the actual release of the funds for the above purposes. Full stop. The court is informed that the proposal regarding restructuring of prisons is under single court's active consideration of government, unquote. Here again, a direction is issued to the Additional Chief Secretary Home to place before the court by the next date the decision of the government on the revised restructuring proposal. Paragraph. June 28th June, 11 at 10:30 a.m.
This unannounced at page 7. I'm sorry, my lord. Unannounced visits, if they can have one more inspection.
You say all the secretaries DLS of the DLSCs are directed to undertake within the next 2 months unannounced visits to the respective jails and sub-jails in their jurisdiction and submit reports to the amicus curiae with a copy being filed, submit reports to this court with a copy to the amicus curiae. These reports positively be filed before 31st May 2023. All right.
We are all grateful.
My lord, certain directions are given to Additional Chief Secretary Home. But this order may be communicated.
Yes. Order will communicate DG Prisons, Additional Secretary Home, all of them, all the Secretary DOS LSA. Thank you, Mr. Chabran, Ms. Pandit.
Thank you so much.
Thank you.
We are all grateful.
Millard,
My lord,
in this case, I am for the petitioner, Millard.
my lord, so far as this item number 1 is concerned, last date he said that I am filing an additional affidavit and your lordship has directed to take instruction and copy may be served. As I find that the copy has not been served on me, your lordship may give me 3 days time. Today, give the kindly serve me copy. Monday, I will take instruction.
Millard,
Personally, if he is filing it in counter, it is difficult to get it. Personally, he is on each date he is coming on VC, so I am unable to approach him to serve the copy personally.
Millard, this is my receipt, Millard. The copy has been served on him, Millard, on the opposite party state council. This is the receipt I am holding on my hand, Millard.
Monday, your lordship may fixed. Monday, another copy may be. So you might have served it in the counter, in the office counter.
Yes, I served it on counter, Millard.
Yes.
I served it. This is I am holding.
Sir, do you have
Another copy I will, as per the approach of my learned friend, I will serve another copy, Millard. Today I will serve.
All right. Mr. Parida states that he will serve today another copy of his affidavit,
Additional affidavit.
of the additional affidavit on Mr. D.K. Manthi, learned AGA, who seeks some time for instructions, some further time for instructions.
Millard, my humble submission before your lordship is that in the meantime, a direction be given for a supply of copy to the learned advocate appearing for Lord Jagannath temple.
Oh,
Because the land belongs to them.
yes. Another party is there, trust, temple trust. He is to be noticed.
Temple, Millard. I
You
will
have not served
them
him?
copy. Yes, I will serve them copy.
I will serve. Acha. We will also serve another copy on the temple, on the Council for the Temple Administration. List on 29th March.
Item number 2.
May be permitted to argue on behalf of L.N. Patel, my lord.
Yes.
My power is not there, my lord. From the Alumni Association of Lajpat Rai College filed this petition, my lord. And they have filed the representation annexure 4, 5, and 6, my lord, before the authority, my lord. There are threefold of the prayer, my lord. Direction to the opposite party provide funds of construction of a new building, my lord. The college in question, my lord, actually 56 years old, my lord. Though 5 acres land, my lord, leased out in the name of the Samlapur Institute, my lord, that has not been till today, my lord.
This is a government college.
My lord, law college, my lord.
No. Is it government college or private college?
Government college, my lord. But the petitioner being the secretary of the alumni, my lord.
All right. The petitioner's representations.
Annexure 4, 5, and 6,
5 and 6 shall be examined with the Tahsildar, Sambalpur, and after notice to the petitioner and giving them a hearing, a reasoned order shall be passed not later than 15th May, 2023. Copy of the decision be provided within a week thereafter to the petitioners. The court clarifies it is not expressed.
Supplementary list item number 3.
This is a GST first appeal matter, not the second appeal. And here the tax, penalty and fine has been paid in full, my lords.
All right. Mr. Kar informs the court that the entire tax, penalty and fine has been paid till the next date. During the pendency of the writ petition, no coercive action will be taken. List on 4th October.
4th October?
Yes.
Item number 4.
Yes, item number 4 is also the GST appeal. Your lordship may pass 20% order.
All right.
I have
10%, 20%.
corrected order I am filing.
No, this is for 5th October.
Plus item number 17 also is also
17.
19 minor. Sorry, 19 minor. 19.
19 also same. All right.
Obligation.
Your lordship, I am appealing the opposite party number 1 to 4 and 19.
Okay.
Item number 5.
Item number 5, my lord. It's a notice which has been issued under section 73 of the GST Act, my lord. We have filed a reply to that. My lord, that reply has not been considered and the order has been passed without considering my reply.
Against the first appeal.
Against the first appeal.
So same 10%, 20%.
Your lordship.
Same 10%, 20%. So 5th October. All right.
Item number 6.
My lord, the substantial question has been raised at page number 7. But the question is very important. Whether the Honorable ITAT was correct in ruling that finding of the DDIT can be used by the AO in the assessment proceeding when the DDIT is an assessing officer as per clause 2A of the 2A of the Act. The DDIT is also an assessing officer and the digital evidence has been verified by the DDIT, not opened by the assessing officer, but by the DDIT. Then the question is whether Honorable ITAT has erred in law in concluding that the AO has merely reproduced the appraisal report in his assessment order without question D, assessment order without verifying the contents of the digital service evidence, although the issue contained therein were properly confronted to the assessing before completion of the assessment proceeding, and is the digital evidence which has been considered by the CIT appeal as well as the ITAT, whether Honorable ITAT is erred in law in concluding that the AO has merely reproduced the appraisal report in the assessment order without verifying the contents of the digital evidence marked as BDJC 27 and CWC, which were not non-digital evidence like loose sheet bunch marked as VDC, which were duly verified and confronted to the SSC before completion of the assessment proceeding. One of the tribunal orders. The first is the demand, the question basis of demand is the undisclosed investment in silver stock 9 lakhs, undisclosed investment in stock in trade 1 crore 77 lakhs, undisclosed sales goods 2 crore 19 lakhs, and cash in 23 lakhs. So all thing has been mentioned in the assessment order. CIT appeal allowed the appeal. Tribunal also allowed the appeal. The page 59 in the assessment order, during the course of assessment proceeding, SSC has not explained, furnished the reason for increasing the valuation of stock. SSC has increased value of closing stock while computing revised income for filing of return under section 153A. SSC has not increased the quantity of stock of jewelry, gold, but increased the value of stock. Accruing profit during the year is increased. In fact, the disclosure petition 132.4 dated 10/12/12, the Nandikishore Agar Tribunal has admitted that there is a discrepancy in the valuation of stock. He then offered an amount of 10 crore for taxation for such discrepancy.
So it's all dealt with, sir, in the impute order of the tribunal.
Then
Come to para 18, sir, page 54, 53, 54.
tribunal order, yes.
Para 18.
Yes. Yes. Or 42 minutes.
I don't know if you have the paper book, sir. Page 53, para 18.
Page 43. 53.
Just give it to me.
Yes, para 18. It must be mentioned here that the perusal assessment order at page 2 or 4 shows that AO himself has categorically admitted that he has extracted the investigation done and the conclusion reached by the investigation being and that he has been reproduced. Thus, clearly, para 4 of the assessment order is nothing but the extract from the appraisal report. In para 4 of the assessment order, the AO has made the gist of the para 4, which is extract of the appraisal report in the form of show-cause notice to the SSC. This makes it clear the AO, when completed the assessment, was not privy to the extract of the seized material, namely so and so. A perusal of the paper book filed by the SSC as page 27, which shows that pen drive as CWJ 12, and at page 14, which shows that the hard stick working of VDJC 27 admittedly has not been seen by the AO. In his written submitted, learned CIT DR stated that the learned AR of the SSC, Sri Ketul Set, went to the office of the AO, which was on computer and software on 15/12/2007 to take out the extract. For a moment, if you see the date of 15/12/17 with the para 5, the assessment order, where the AO has mentioned the show-cause notice, the show-cause notice was been issued on 8/12/2017, much before the opening of the hard disk or attempt to open the hard disk. Thus, clearly no data was available by the AO other than the appraisal report when he issued the show-cause notice. Now coming to the date on 15/12/2007, a perusal of the Mahajanama, which has been prepared by the Assistant Commissioner Income Tax, Central Circle, Cuttack, in the presence of 2 witnesses, and the SSC authorized representative, Sri Ketul said it mentioned that the seized material being BDJC 27 was found in the sealed position and sealed intact. This is obviously before 15/12/2007. The seized material has not been opened nor examined. Now we are in the Mahajanama prepared by the Assistant Commissioner Income Tax, Central Circle, Cuttack, mentioned that the authorized representative of the SSC has come with
So
the.
what have you to say to all this?
Yes.
What is your submission?
Yes. That is why I said the assessing officer.
Just mechanically reproducing materials. He's not even looking at all the materials.
DDIT is also an assessing officer.
No application of mind at all, sir.
The DDIT is an assessing officer. DDIT is open the seized material. It is not necessary to open the.
No, you have to apply your mind, sir. This is not just for reproducing whatever is there.
Let issue notice may be issued.
No. The present appeal by the revenue is directed against the judgment dated 26 September 2022 issued by the passed by the Income Tax Appellate Tribunal, Cuttack Bench, Cuttack, bracket IT-80. Dismissing. Sorry. Allowing the appeal IT bracket SS bracket. Dismissing the IT bracket SS bracket A number 77. How many appeals have you filed?
2 appeal. It's 26/27. But 3 appeal is there.
Where is 26 today? There's only 27.
It's not listed.
Then you take it on board. Which are the other 2 numbers?
Only 26 of 2023.
26 of 2023.
No. What is before us is 27.
Yes.
You have filed only 1 more.
Yes.
But there were 3 appeals in the IT-80.
It's below taxable, below monetary limit.
Oh. Then you said taken on board 26 and then both these appeals. What is the corresponding IT number in the tribunal?
78
and
77. It is
77 and
77. 77, 78.
78.
78 and 79. 78 and 79.
No. The present 27 of 2023, I think it's against 77.
79 of CTC 2009.
Sorry?
79.
79.
27, this 27 of 2023 is against ITA 77.
Yes.
No. Lordship, 27 ITAs of 79 of CTC.
Just show me the hard copy.
ITA number 79. This one. Page number 10.
Tribunal order.
They're wasting time of the courts. Really. Sure.
Correct. Correct.
No, which is the other one? This is 77. Which is the other appeal?
77 and 79.
79.
Nice.
All right.
Number has been
Against
number.
ITA SS numbers 77 and 79 oblique CTK oblique 2019 for the assessment years 2012-13 and
16-17.
Can it be 16-17, sir? What is this? Acha, 16-17. 16-17. The questions sought to be urged by the revenue. R is under C, D, and E, pages 7 and 8. Paragraph. This court has heard the submissions of Mr. Chimankal and Senior Standing Counsel for the Revenue. Paragraph. The SSC is a partnership firm engaged in the business of jewelry, precious, and semi-precious stones. A search was undertaken at the premises of the SSC on 9th December 2015, followed by a notice under Section 153 Capital A of the Income Tax Act, 1961 Bracket Act. On 10th January 2017. Full stop. Certain loose sheets, bracket identified as VDJC21. The register, bracket identified as VDJC25. And a hard disk and its extracts, bracket VDJC27. Was stated to have been found in the course of the search. Before the CIT bracket A, the SSC claimed that the assessing officer bracket AO had not given copies of the seized materials extracted from the hard disk and the pen drive. The CIT called for a remand report from the AO. By the time the report could reach, remand report could be submitted, the AO changed. The AO had tried to open the hard disk in a standard computer, but was unable to do so. In the remand report, while stating this fact, the AO provided a soft copy of the hard disk and pen drive to the CITA. The ITAT is noted in the impugn order that the AO has simply reproduced the appraisal report and has not undertaken any analysis of the seized materials. Stop. Even the hard disk with the working copy was not seen by the AO. Sorry. The seized material had neither been opened nor examined. The expert report also failed to point out that the software was single quotes hardware specific. Stop. In this respect, the ITAT has made the following observations. This take from page 55, the second line on this point, up to end of para 18, rebuttal paragraph. On perusal of the assessment order in some detail, the ITAT concluded that the CITA was right in holding that the additions made in all three AYs was open quotation in total violation of the principles of natural justice, and that the additions have been made clearly on estimate basis, unquote. Paragraph. With there being concurrent findings on fact by both the CITA and ITAT, and with there being clear violations of the legal requirements by the AO. This court is unable to find any error committed by the CITA or the ITAT in disagreeing with the AO and setting aside the assessment order. Paragraph. No substantial question of law arises. Appeal is dismissed.
Item number 7.
Lordship, in this writ petition, the petitioner challenges the virus of Rule 6, explanation 1 and 2 of Rule 6 of the Self Credit Rules 2004.
The petitioner never went before this NCLT.
The company was under the NCLT, and therefore, in the last date, it was ordered for filing the amendment to the cause title, which I believe has not yet been filed.
Who is going to do it, and when do you propose to do it?
Shortest possible date may kindly be given to me. I'll file it immediately. Oh, it has been submitted. I have been advised by my lord. Right.
Lordship, I had instructions to file them, and it has been filed. It is yet to be tagged with your lordship's record.
Has it been numbered?
Yes, your lordship. IA number 3136 and 3137 of 2023.
All right, just take it on board. For the reason stated therein, the applications are allowed. The amended cost title is already there.
We are filing a substitution application to substitute the cost title. So that
consolidated
that
cost
will
title
be
now
done.
be filed
Yes,
within
your
a week. In the main matter, you say list on. April.
Obliged to lordship.
Item number 8. But here, Lord, last occasion on 1st March, Lordship directed to obtain instruction by the government. With regard to Lord, here the government heard the matter with the grant of on license on 3 points, but collector has gone on another point that they have admitted in the counter affidavit to Lordship kind of glance, para 7 and 8 of the counter affidavit. That they have gone to the other points of the which was in additional secretary has been raised, but they have admitted. So they cannot, that is regarding, they are saying the on-sub should be on commercial building. But Rule 51(2)(d) says the approved building plan should be submitted by the applicant. But I have submitted. That was not the point before the government to consider my application for
I'm not able to understand. So this is a counter affidavit filed, is it?
Yes, my lord. The Lordship kind of glance Annexure 6. Annexure 6. Lord, my counter they have filed on 6th March. Lordship's directed to obtain instruction whether the collector has gone beyond that points raised by the additional secretary excise department. Lordship, may I hand over to Lord?
So we are unable to find any counter affidavit.
This is the hard copies are with me. We filed on 6th March 2023.
That must be the last day. Monday evening must be. It does not come on boards.
Lordship kind of glance para 7. Para 7 and 8. But I have marks in pencil. Towards bottom, Lord, they have said that on confused points by the collector has gone to the
viewpoint.
Hey.
This is very obvious. You can't open it in the residential.
No, it is.
I'm appearing for the objector.
Loss is 51 Lordship kind of glance 51(2)(d). What is the requirement of? It says copies of record of rights, municipal/NSE holding number, and copy of the approved building plan. But I have filed approval of the building plan.
No, but if the building is a residential building, why will they allow a on shop there, sir?
No, that is not the requirement, Lord.
What do you mean?
No, nowhere, Lord. They have Lordship kind of glance.
You mean in a residential building you will have an on shop?
Lord, on the map they are allowing. Lord, collector is allowed. In other cases, Lord, they have allowed.
No. If I'm allowed to have a substitute.
Yes, Lordship kind of glance. I have given the structure where I have given. That is, Lord, entire 3 rooms are there. But there one room is fertilizer is going on, one room is marble is going on, and my third is this restaurant I'm operating. But entire building is Lord. But I have that part also have applied.
I don't know what this is. Bhubaneswar, is it?
No, Lord, it is Nilagiri, Lord. Nilagiri NSE.
Baleshwar district.
Baleshwar district, Nilagiri NSE.
It is a residential house. Some portion has been let out to 2 different shop rooms, and this one they want to use as a on-shop. And collector has said this is not a commercial area. So on-shop license cannot be allowed. That is the only point.
If Lordship would kindly look at the prayer.
Lordship, I have given the Lord structure of the at page 33, a photograph, Lord. One marble room is there, marble showroom, and Lord, one is agro industries have opened, and in third room I have opened. It is entirely the entire building has been converted to commercial, Lord. And Lord, that about I have applied also before the Nilagiri NSE, but I have applied for a conversion of that.
There's a marble shop.
If I am allowed to make a submission, Lord, I am for the objector here. If Lordship look at the prayer here, it's completely premature. no decision has been taken either by the government or by the collector.
No, counter, they say that.
No, kindly see, my lord, the prayer. Collector has not taken any decision. Collector has only noticed him to appear before the collector.
No, all that is over, sir.
Yes, already.
It's not that over, my lord. Collector once submitted the matter to the government. Now, government page 26, your lordship may kindly see. Page 26. Government called upon him to submit a reply on 3 basic points, my lord. Kindly see page 23 and Annexure 6. Now, thereafter, government has, 1 second, Mr. Thereafter, government has referred the matter.
You are not going.
Thereafter, government has referred the matter, has sought for some instruction from the collector. And at this stage, he has come before your lordship, my lord. The process has not been completed at all. It's premature, too premature enough, my lord. He's trying to prejudge the whole issue before your lordship, my lord.
Not here, government has asked the collector to submit the views on these 3 points.
Yes.
So, but now he has gone to the another point. This is the commercial. That is not the point where the additional secretary. Government has not raised that point.
He must
that is not the requirement of law. That is not the requirement of law.
Just 1 minute. Has the final decision been taken?
No, my lord.
No, my lord.
Because of this collector's attitude, he has not taken a decision.
What attitude? What attitude? Your lordship he is saying that you are asked to give opinion on certain points. You cannot go beyond that. And collector has not given any decision yet. The allegation is that collector is observing that he is this is. So let him give the report. If the government will not act upon, government may act upon it, may not act upon it. So you should not. This is all premature allegations.
But I am filing the rejoinder also.
Counterfeit once you say this is in a residential premises, then isn't it obvious that the government will refuse?
No.
You have said in
internal page collector's 5. Collector's view that it is a residential zone. You cannot allow.
So beyond this, will they actually grant the license once the collector says it's a residential zone?
Besides that, there are other serious objections. Kindly see page 26, my lord. This proposed location. 1 second. This proposed location is under 400 kV electricity supply, under which there is no establishment can be there under the high voltage power supply. Rule 80 of electricity rules completely prohibits that. And on that point, the government has also asked a report.
That I am satisfied.
Satisfied. No,
may I suggest one thing to your lordship? May I suggest one thing? The government may be directed to pass to give necessary opinion, and whatever the collector will take, that will not be binding on the government. That will never be binding on the government.
No, but why
take an independent decision.
So special about all this that we should interfere now? I don't understand. Why are we?
The rule doesn't permit. They have granted, rented, where holding number is there. I have the holding number. I've got the holding number. I have got the approved building plan from the executive officer, Nilagiri NSE. But I have submitted all the things. That's why government has called for other points. Not on that point. That was also before the government. But I filed rejoinder, lordship kind of glance.
Hearing was on 27th January. Thereafter, what happened?
Annexure 11. Lordship kind of glance the government's letter. After hearing the matter, page 7, Lord. Page 7. Specifically, government asked for the 3 points, not on the other points, Lord.
No. You want the court to rule on all of this?
No. My submission is that
if you insist that we'll argue on these points,
my submission,
residential, non-residential, permissible, non-permissible.
But my
we'll reserve orders and we'll pass.
My submission is before your lordship is that let the collector submit his views as per the direction of the government.
Since you want this entire elaborate thing decided here, we'll do it.
I'm not saying we'll
do it.
But that's why
come to the court, sir.
But that's why my prayer
come to the court elaborately raising all these points.
That's why my prayer is let there be direction of the government to consider.
We'll decide it. We'll decide it.
That's why my prayer, sole prayer, I don't have any prayer. In the writ petition, I have the sole prayer that let the government take a decision. Once government call for views,
will deal with their counter, your petition.
I'm not saying.
Your rejoinder will give a judgment.
That's why I have given a lordship's order also in the rejoinder. Where your lordships are directed.
Give an elaborate judgment, sir. Since you want to elaborately argue, elaborate judgment.
No, I'm just saying one.
The judgment is going to become. So now you decide.
The lordship may direct the government to consider.
We are not here. You argue, sir. It is us to decide. You can only argue, correct?
No.
Of course. If you want to decide, then don't ask us to decide.
No, that is.
You argue, we decide.
No, that is.
The more you argue, the more we'll decide.
The lordship directed after instruction. Because they have filed counter, I have filed also.
All right. Orders reserved. Orders reserved.
My prayer
is. We'll elaborately deal with all your arguments.
Just 1 second, my lord. Lordship's order also have annexed in the rejoinder.
Orders
Lordships have said that
Orders reserved.
collector will submit his views and
Orders
government will
reserved.
consider.
Orders reserved.
That I require, Lord.
Orders reserved, sir.
Item 9.
Lord, it's a writ appeal.
Yes.
I am aggrieved by only a observation by the Honorable Single Judge. It's a settlement matter.
Yes.
I was aggrieved by the order passed by the Assistant Settlement Officer.
Yes.
In the framework of settlement law, my lord, and
Not may I submit. Lordship may only direct or otherwise I'll withdraw the matter. Because otherwise, Lord again,
Council will withdraw petition with liberty to urge all points to the appropriate stage.
before the government, Lord.
Dispose of at the appropriate stage before the appropriate authority.
wide enough.
Disposed of is withdrawn with liberty is paid for. All right.
Lord, oblige.
Item 9.
Page 15, your lordship would kindly see the order passed by the Honorable Single Judge.
Yes.
Survey Settlement Assistant Settlement Officer's order. In fact, in the framework of Settlement Act, 15B revision is maintainable. But then the Honorable Single Judge says that find the controversy involved and cannot be entertained and adjudicated by the settlement authority. It's completely wrong, my lord, contrary to the Settlement Act itself. And otherwise also, my lord, this whole issue will be covered by your lordship judgment in that Narottama case. Yes. So either way, your lordship may dispose of the matter with liberty to me to approach for the take all this point with the judgment passed by your lordship, my lord. Or
then you have to withdraw the writ petition itself, sir.
Lord, withdrawal would not help me, my lord. Kindly consider the issue because this Honorable Single Judge has said that settlement authority cannot entertain it. Once this observation remains, my lord, it will cause difficulties for me because they will say that we cannot entertain it. 15B says that they will decide all the disputes against the subordinate officers of the settlement.
But there is a observation, nothing prevented the petitioner to approach the competent authority for remedying out of
Not once you are saying that the settlement authorities have no jurisdiction to decide any dispute. Kindly see the order, my lord. Kindly see, para 3. This court finds controversy involved herein cannot be entertained and adjudicated by the settlement authority. Where shall I go? 15B is a statutory remedy available to a person. He has to approach the criminal authority against any kind of wrong committed by the subordinate settlement officers. And this is for the same moja where Narottama Ratha's case is decided, Ugalpada.
That is
your lordship may say, I'll approach without being influenced by this order. He will consider it in the light of your lordship judgment. That will do, Manos.
What do you say, Samantha?
Let him approach the RP court.
All right. The present appeal is directed against an order dated 26 September 2022, passed by the Lord Single Judge, dismissing writ petition civil 39387 of 2021 filed by the present appellates.
Will approach the commissioner under section 15B who will decide the case without being influenced by the.
All right. The challenge in the present writ petition was to an order passed by the Assistant Settlement Officer.
Assistant Settlement Officer.
Assistant Settlement Officer under the Orissa Government Land Settlement Act.
Orissa Survey Settlement.
OSS.
Survey, yeah. Orissa Survey and Settlement Act. Bracket OSS Act. Of the learned single judge has, by observing that controversy cannot be entertained and adjudicated by the settlement authorities, precluded the appellate remedy available to the
revisional
remedy available to the present appellants under section 15 bracket small b of the OSS Act. Paragraph. In that view of the matter, it's clarified that notwithstanding the impugn order of the learned single judge, it will be open to the present appellants to assail the order of the ASO before the revisional authority in terms of section 15 small b of the OSS Act. The writ appeal is disposed of in the above terms.
Exactly. Great.
Item number 10.
May I please, Lordship?
Yes.
No, this is for second round, Lordship, and I have complied Lordship's direction. And I have at running page 46, Lordship, I have approached before collector that is on 9th January 2023, and being agreed by the inaction of the collector,
All right.
again I compel to appeal this honorable lordship.
All right. The petitioner's representation dated 9 January 2023, bracket annexure 5, will be examined by the collector, Cuttack, and after notice to the petitioners and opposite parties. No, there's no opposite party.
I mean, all tahsildars are there, lordship. He is subordinate, lordship, because all are there making law, lordship.
And after taking inputs from opposite parties 7 to 13, as well as the State Pollution Control Board.
So also government guidelines, lordship. I have annexed the government guidelines.
I think in this case, collector should hear the stakeholders also. He wants to, he says that some illegal mining going on by some lessees under this district. So those,
which are those lessees?
Lordship, kindly come to page 6.
They are not made parties. Still the collector can notice them.
Collector can, because of the inaction of the collector, lordship, kindly see annexure 6. Page 49. This is the government circular.
No, but who's operating, sir? Who's illegally operating?
In fact, lordship, kindly see here it's blood operating in the Kathodi River, lordship.
Lessees.
You have to find out. See, again, what will happen otherwise, this will all become counterproductive. If they pass an order, some 10 others will rush to this court saying behind our back, Mr. Dalai got this order.
But lordship, kindly,
and they'll probably say Mr. Dalai was at the behest of our rivals. All that will start.
But lordship, kindly page 41.
Whereas Mr. Dalai is genuine public interest, correct?
Lordship,
you only pick up genuine public interest causes.
Lordship, kindly page 41 for moment.
I also
kindly lordship, page 41 for moment. Page 41, lordship. Only this aspect will consider, lordship. Nothing. Lordship, page 41. That is, lordship, C, acquiring mining operation. That is Roman.
Is fine, sir. So
no,
somebody is violating this.
No, the restriction of machines, lordship. You cannot extract hands by mechanized manner. This is the government policy.
And
only that has to be checked. No,
not for check. Somebody is doing it right now, correct?
Everybody is doing, lordship.
Which is this everybody?
But lordship, kindly see, if lordship, you take example of this Kathodi River, lordship, see minimum hundreds of proclaimer working.
No.
So lordship, it is.
I were in your position, at least I'll name 3 of them. I may not get 100 names, at least I should get 3.
All the leaseholders, lordship, if they have granted lease.
Suppose we say, no, today I'll pass an order saying everybody carrying on illegal mining in Kathodi River are impleaded. We'll simply say from as opposite parties 2 to unknown number.
No, rightly, my senior.
And now you'll have to go take notice. We'll permit you to serve them. How will you serve them?
But lordship, my senior rightly pointed out, the stakeholders means it is issued by the collector. So collector can issue the notice them, lordship.
Who notice to whom?
The collector is granted the lease, lordship.
No. To whom will issue notice?
Below those who will participate in the auction, lordship. Those persons have applied in.
So something you'll have to find out. If you say people who have been issued licenses are exceeding their license, suppose I've got a license to extract X amount. I'm extracting X plus 10 amount.
Definitely, lordship.
So that person who's extracting more, at least he should be named. Suppose you say, sir, without license itself he's extracting, then at least that person should also be made party.
But my humble submission, those have been licensed, lordship. Those have been licensed.
Then it's easy for you to find out.
No, that is there, lordship.
Some homework has to be done, sir.
If lordship said, then definitely I'll obtain on RTA. But you lordship direct to collector. Collector can furnish the names, lordship.
The only problem is, if he pass these kind of orders, will multiply litigation.
No, if lordship said I will approach your collector take a decision, I'll provide the names also.
Even a collector, sir. So if he does not have names, whom will issue notice?
He has purchased the names because he has granted lease. Collector is granted lease.
You have to make some allegation that X to whom you have granted lease is extracting beyond the permissible limit.
That is my entire submission.
No. Where have you named?
But that's why I have named all the tahsildars, all the sources I have, lordship.
No. I think you're not understanding or.
No, I am understanding, lordship. But you, lordship, putting me in such a problem, lordship, it is never possible.
Problem, there's no
lordship kind of land.
You are a genuine public interest person. What problem?
Your lordship,
you're interested in upholding public interest.
Yes, lordship, for a moment, lordship, kindly come to the new police page 53. They come up with the interstate permit. They have granted interstate permit.
Correct.
They have entered this to new mafias, lordship.
Correct.
So no person in the state, lordship, can gather courage to approach this honor by naming a person. Lordship, they're international persons, lordship. Those are.
If Mr. Dalai lacks courage, imagine ordinary persons.
No, lordship. I am being a counsel.
Courageous person, sir.
Lordship,
See, the minute you have courageously come to the court, you have to courageously
if you
find out.
say, then I produce the names, Lordship. I have this courage, Lordship. I can produce the names. But Lordship, then Lordship, kindly adjourn to next week. I'll produce all the names, Lordship.
Not here. First of all, name it. Give
that's why I'm saying, Lordship, say I will appropriately collect all those names.
Mr. Dalai seeks leave to withdraw the present petition.
Again, would Lordship? Because Lordship,
dismiss it saying
it creates Lordship
bad for non-joint parties.
No, Lordship kindly see. Constance Lordship Shadar, page 46, I approach Mr. Collector. Collector is still sitting over the matter. Only Lordship can direct a collector to take over my matter. And Lordship say me, I will supplement the names, Lordship only. I will supplement the names those who are operating. If Lordship say liberty withdrawal, they will take another 6 months time. And Lordship by this way, Lordship, it is a huge corruption. Lordship can see if the other part, Lordship can see today, I have taken 2 parts in this writ application, Lordship. One is illegal mining, other is unorganized transporting, Lordship. And Lordship, today I was 15 minutes late to come this court because of this transportation, Lordship. All the trucks in the daytime is coming on the road and they are blocking the roads. And it is Lordship very visual. Lordship can visualize also. Lordship is doing a great job also without protocol. Lordship traveling in Cuttack City. If Lordship must every day must have faced the same difficulties. These trucks are moving on the road in the daytime.
See, we're all deeply conscious. If I walk into the marketplace, nobody recognizes.
Lordship,
nobody will know. Only we presume nobody's carrying on their own lives, sir. Nobody's bothered.
But Lordship kindly see. So this unorganized transportation has to be stopped also. School time, the school boys are coming. Lordship kindly and the entire traffic is Lordship due to this illegal transportation.
What normally, even for a collector's point of view, if you do not name people,
I'll name the people. Lordship say I'll approach the collector.
You have those names with you. Then we'll say you have the names.
Yes, I have the names, Lordship. I have the
names. The names.
Lordship, in fact, Lordship, I have all the agreements, but unfortunately, that is not on my this.
So you can adjourn it to provide the names.
Lordship, can adjourn, I'll provide the names.
Mr. Dalai.
Monday, Lordship, say Monday. Better.
All right. Maybe one more way. One.
No, Lordship. No, Monday will suffice for me, Lordship. I have the names.
All right. Mr. Dalai states that he will provide names of the alleged violators of the instructions governing the mining leases in question. At his request, list on
13th,
16th, 3 more days.
Lordship. But Lordship,
then your list can expand a bit.
Another next day, Lordship will grant another relief to give protection to my client also, Lordship, because Lordship know who are they. Lordship.
Item number 11.
May I please, Your Lordship. This is a PIL, my lord. A PIL has been filed after obtaining information under the RTI Act. Before going into the fact of the case, I would like to draw Your Lordship's attention. The Rule 51 provides it fixes the guidelines for grant of on-shop license, my lord. May I read, my lord? Few paras I would like to read.
So what do you do, sir?
So I am a social activist of that area.
It is against opening of...
Against, my lord. Why I am showing, my lord? Lordship may see the 51 what says. Subject to provision of the rules.
So are you a teetotaler?
My lord?
Are you a teetotaler?
Atithi.
No. I am against the Atithi, my lord.
I don't know. But are you a teetotaler, I'm saying?
No. No.
So you go to some shops to buy?
No, never.
You don't drink at all?
No, my lord.
I'm not asking you. I'm talking to your client.
My client, I can't say most thing about my client.
You should find out.
But what happened? The rule says always on-shop license.
No. Then you should ask your client if you do enjoy your drink. Where do you buy your drink from?
Perhaps he never drinks.
That perhaps is very important, sir. That perhaps is very important.
But let's see for a moment. The rule says...
I'm asking these questions out of... It's got some meaning, these questions. Is it genuine public interest or not?
Genuine, my lord.
How do we know?
Yes, Lordship may see. The rule says...
No, rule will say so many things. We are about your
why Lordship will find in 2 districts.
Lordship may first ask him one question. Whether he has lodged objection within the period specified in the format notice.
Yes.
Has he?
Yes. No, my lord. Lordship
Because he is not
confused. I file an applications That was given after 40 days. 13/1/2023, all the documents were supplied. Then I immediately approached the collector. So these are the points. There is irregularities committed by the inspectors. You have processed the application and sent to the government. Rule says the hotel must be having a full license, GST, income tax returns. Nothing is there, my lord. Lordship may see for moment. His application.
If nothing is there, government will reject it. Why you are worried?
Yes, only, my lord.
Because your decision. He was arguing in a case where your lordship has held that if you have not lodged the objection within the specified period as per Form 8, then you have no right to raise that point in a later stage.
Page 16. Only one point I would like to. Page 16, the online applications. How he has the OP number 5 has manipulated, my lord. Lordship, this is the application, online application submitted by OP number 5 on 19/7. Lordship may come to column number 2 of application.
One question can be asked. You are a Baleshwar person, right?
Yes.
How many licenses are issued for Baleshwar alone?
Well, this type application, 14 on OPSOP has been issued.
Now, on these 14, why did you pick up only this?
Areas.
No, why did you pick up only this?
Only because I am residing at Nilagiri, within the Nilagiri NSC. Nilagiri NSC. It is adjacent to the Baleshwar town, my lord.
It is Nilagiri. Item number 8 was also Nilagiri. There somebody was supporting here.
Because in there, my lord, there is fraudulent violation of the rule, my lord. Whatever they want to do, they process the file and send to the government. Lordship, with the person, he had no full license by 19th. That is more clear from Annexure 6, page 28.
So this representation, what happened?
Nothing, my lord.
No, when did you do
without
that? Is much beyond the
No.
period.
After getting the application on 17th month, I have filed this application. On 1st February, the collector has processed the file and sent to the government.
Where do we know you gave it on 17th?
That 4.12 paragraph, page 8 of my written application.
Where is the proof?
Where is the proof? 4.12. The action of the collector so and so. The by the order dated 1342 dated 1st February 2023, collector has recommended the file to the commissioner. Thereafter,
No, I am on something else, sir. This representation, which is at Annexure 7.
7.
What is that to show you gave it?
That the person who had submitted online application, he had no full license, he had no GST, he had no income tax return.
Proof of submission.
Asking you something else.
I have given, madam. Genuinely, I have given.
What is the proof, sir?
It can be ascertained. Collector can say because he has received a track report, everything.
Then I have to take time. You are only 15 days in your hand.
Mind.
You give us proof, sir. We are not entertaining these PILs without proof of giving the representation.
Generally, he has sent to the collector. Collector has received it.
How do we know that?
This fact can be ascertained from the collector.
No. You have to get a stamp wherever you give a representation.
So let it come next week, my lord. File my proof regarding service of this representation.
All this you have to do, sir, because we don't have time for this. All right, counsel to the petitioner wants time to produce proof of having submitted this representation to the collector at his request list on 29th March.
Item number 12.
Your Lordship, item number 12 and 13, we have to check it out the record of issuance of the amendment requisite.
Sorry?
I have to verify that requisite has been filed out.
No, not 2013 matters.
We have already admitted and
no.
Let me pass over then. Mr. Satpathy will take them.
Submitted or not?
12 and 13.
Requisite's not yet filed. Despite this being a 2013 appeal, the court is not prepared to grant further indulgence to the appellant for filing requisites pursuant to notice issued in the appeal more than 2 months ago on 9/12/2022. The appeal is accordingly dismissed for non-prosecution. Same for the next one.
Item number 14.
Your Lordship may be permitted to withdraw the matter.
All right, dismiss as withdrawn. Obliged.
Item number 15.
Item 15, my lords. It is covered under ECMA's judgment, my lords. Item 15, my lords.
All right. In view of the judgment, You just say admit the following question of law is free for consideration. Whether in view of the judgment of this court in ECMAS, the impugned assessment order and the corresponding orders of the first appellate authority and tribunal are liable to be set aside. Paragraph. It is not in dispute that the assessment order under section 9,
10, my lords.
Under section 10 of the Orissa Entry Act, Tax Act 1999 was not preceded by communication by the department to the SSC of acceptance of the self-assessment return filed by the SSC for the same period. In view of the judgment in ECMAS, we impute and corresponding orders of the first authority and the tribunal hereby set aside. The question is answered in the affirmative in favor of the SSC and against the department. The revision petition is disposed.
Item number 16.
16, I pray for 1 week time to remove the defects.
List on 12th April, defects be removed in them.
Item number 17.
This is against the GST appeal order. 10%
First appeal order, 10, 20.
I see, 10%, 20%. List on 4th October.
Item 18.
Item 18 also against first appeal under GST.
All right. 5th October, you know this. All right.
19 already taken. 19 already taken. Item number 20.
May it please, Your Lordship.
Same.
Your Lordship, same.
10%.
20, 21 and 24.
All right. All 5th October.
21 copy may be served.
Serve it within the court.
Item number 22.
My lord, in 22, I have already deposited the entire tax amount.
All right. Entire tax has been deposited.
Subject to verification. Along with interest. I have given the
all right.
proof also.
5th October. All right.
Item 23.
May I please, my lord? Item 23, my lord. Due to huge financial difficulties, my lord, short payment during the filing of the appeal, my lord. So, my lord, kindly allow me to deposit the remaining amount and appear before the first appellate authority, my lord. My sole prayer, my lord.
What's the amount, sir?
My lord, total amount, my lord, payable 1,30,000, my lord. I have paid only 62,000, my lord, some odd, my lord. The remaining amount is, my lord, 69,716, my lord. So I am ready to pay the entire amount, remaining amount. Kindly allow me to deposit the amount and allow me to appeal before the appellate authority, my lord. Appeal will be only rejected because of non and short payment of admitted tax, my lord.
No, but what is the order you're challenging? It's not clear. Come to the prayer clause.
My lord, prayer, my lord, direct to the office partner to pay the balance 10% of tax demand for the period of 1890.
Sorry, just read that prayer clause carefully, sir.
Under the official facts and circumstances, it is humble prayer that the Honorable Court may graciously please to issue notice to the opposite party is direct to the opposite party number 1, that is the Joint Commission on Appellate Authority, my lord, to allow the appeal after direction to pay the balance 10% of tax demand.
Allow the appeal? How can we give a direction to the authority to allow the appeal?
Not allow, my lord, this is wrongly drafted.
So who will do the correct drafting? Justice Satpathy is a bit busy, sir. He is not able to do the drafting. I am also a bit busy.
Wrongly, my lord. I
who will do the drafting? Some difficulty, no, sir?
Yes, my lord.
As judges, we are very busy. We are not able to do the drafting for you.
Yes, sir. Sorry, my lord. Sorry, my lord. Kindly allow me to deposit the rest of the amount, my lord. So,
without correct draft of your appeal, we should give you all the relief.
Okay, my lord. Let me allow to correct the prayer person, my lord.
You don't want to correct it, or we should ask you to correct it, or will you request that you want to correct it?
Sorry, my lord. I will draft, my lord. I will correct, my lord.
Counsel for the appellate. Petitioner seeks leave to withdraw the present petition with liberty to file a proper petition. So just spend some time. I don't know, you probably asking some junior colleague to draft the matter. You will only appear to argue the matter. It seems like that. That seems to be the arrangement. Some matters you have to take the trouble of drafting it yourself, sir.
It's, I found that later.
This post office withdrawn with liberty spread law.
Item number 25.
Lordship, in this matter, I'm challenging the parallel proceedings initiated both by the state as well as the central authorities. There is another matter for another period, writ petition 6633 of 2023. Lordship may direct to list both of these matters together and remove the defects and.
All right. You see, list on 10th April, not 10th, you see 12th April, defects be removed in the meanwhile. List along with writ petition civil.
6633.
6633. All right. All right.
Lordship, copy may be served to the
Lordship may kindly list it next week, Lordship, due to.
There's no time. We're all chock-a-block.
Parallel proceedings initiated both by the central and the state authorities.
I know, but we can't. There's no date at all. Right.
Item 26.
Obliged to Lordship.
26 may please your lordship.
Yes, please.
In this case, my lord, the department has come up with the appeal. A revision order was set aside. A revision order was, my lord,
263.
Yes, my lord. That was quashed, and it is against the penalty order. Page 13, lordship kindly the law and tribunal's order. It is, my lord, quashed the penalty order. For that, that has been challenged. In the meantime, a revision order was challenged by the department before your lordship, and that's
already been. Yes. So substantive matter is over.
Yes.
So this is penalty. All right. In view of the dismissal. Of the revenues ITA number 1 of 2023 by the order dated 2nd March 2023, which was on the quantum issue. The present appeal, which relates to the penalty, is also dismissed.
Item 27.
Item 27, dispensing with annexure 2 and 3. I'm filing the copy.
Yes, tell us. Bharat Earth Movers.
This matter may be taken passover for Satpati sir will be taken into the court.
Oh, all right. Then just pass over. Both matters, 27, 28.
27, 28, it has been already admitted on 26th April. The order has been passed similar matter.
In 28.
Dispensing petition I'm giving for limitation and dispensing of annexure 2 and 3.
This Paradip Phosphates.
Paradip Phosphates.
All right. I think omit the first. Mr. Panda is not here. Same. Paradip Phosphates.
Yes, my lord. Copy may be shown.
Yeah, same order. All right. Which one is this? This one. All right. Taken on board and allowed. All right.
Item 29.
Item 29, my lord, this is a Sattaparada matter.
Same order. Delay condoned.
In that matter, my lord, two matters are different. It may be dealing to from the W565 of 2021, 566 of 2021. Two matters are there that are different, my lord. It can be dealing and maybe listed.
All right, 565 and 566. You say at the request of counsel, the appellant list on 24th April.
Madam.
So the others same.
Item number 30.
Yes, item 30, my lords, pertains to appointment under the rehabilitation assistance scheme.
Where is that order?
Yes. Yes, this, although this is a first day disposal, so my lords, let it be remanded.
No, unless the other side is here.
Yes, ma'am.
Are they here?
They have entered appearance though.
It's coming up the first time.
Yes, sir.
Say, although memo appearance is shown on behalf of the respondent, none is sufficient to be notice returnable. 4th July, impugned order shall remain stayed.
Item 31.
May I please, Your Lordship?
Yes, nomenclature not correctly. Contempt appeal, is it?
In view of my Lord's judgment, that writ appeal is maintainable. That
No. Why have you filed the appeal? Because the main writ appeal is pending.
Well, that's the order against that contempt petition. So,
No. The contempt is for non-compliance with something, correct?
Yes, my lord.
That order has been appealed against.
Yes.
What is that appeal?
That I have given. What has happened in this case, my lord? May I draw my lord's notice? The lordship may turn to.
No. First answer the simple question.
My lord.
Against this order dated 9th May 2018, in writ petition civil 25927, have you filed an appeal?
Yes, no, my lord. In page, your lordship may find page 83. What was the direction, my lord? The direction was, my lord, page 86, my lord.
Comply the directions given in some other judgment.
Within form production of certificate, if there stands no such legal impediment. In compliance to the direction of the GIA, my lord, we have passed that order that was suppressed before the honorable single judge. The lordship can find it from page 81.
All right, you just say notice returnable till the next date. The impugned order shall be stayed. List on. 9th August.
That my lord, personal appearance has been direct.
Stayed.
Item 32.
32, my lord, that rehabilitation matter that your lordship may fix it to 30th August. In similar case. Lordship already issued notice that similar matter has been fixed to 30th August.
Notice returnable 30th August, list along with, there shall be a stay of the impugned order till then. All right. List along with this 916. All right.
Item number 33.
Item 33, I am appearing on behalf of respondent, my lord. Dear my lord, the caveat petition was filed on 23rd of March 2022, my lord. And the writ appeal was filed on 13th of April 2022. But till date, my lord, they have not yet solved the copy.
33 the same matter, rehabilitation matter.
Same matter, but
first the disposal, my lord, your lordship.
While the caveat was in force, the writ appeal was filed. They have to serve a copy of the writ appeal, my lord.
Want first day disposal, you can go back.
Page 22.
My lord,
They have not yet served the copy of the writ appeal, my lord.
All right. Say note.
I'll serve.
All right.
And my lord, there is a delay of.
Yeah. So notice on everything. He accepts notice.
There is
time for instructions till the next day. There should be a stay of the impugn order. List on 9th August. All right.
Item 34.
34, my lord. This is also single same day disposal. My lord, sort of.
My lord, it is not the same day disposal, my lord. That writ application was filed, my lord, at least they have taken four occasions, they have taken time to file the counter. Then after 7 months from the date of writ application, that matter was disposed of. Now they cannot take the advantage of their own laches since they have not filed the counter even after getting four chances, my lord. Therefore, the Honorable Single Judge has disposed of this matter, my lord. Now, even
page 17 with the order.
Yes.
That 9th September is also appeal has been filed.
Yes, ma'am. That has been filed and that has been fixed to 14th March.
14th March. Right. List on 14th March. All right.
Item number 35.
So 35 is there. But Annexure 1 is the advertisement that was issued. If your lordship looks at page 19.
Walk-in interview.
This is actually post of vocational counselor. At serial number 4, my lord.
Correct.
But one post was there. I entered appearance, and on the basis of the selection process, actually I was selected. Appointed in the May 2001. 12 years after, OP respondent number 4 here, she was also appointed after 9 months of my appointment, and she challenged the regularization of the petitioner, the appellant for lordship, and filed an OA. The original application court directed no regulation has to be done as per law. I am not going to interfere. Subsequently, after the regularization, again filed another OA, which was subsequently transferred to the Honorable High Court. But High Court, actually, if your lordship looks at the counter affidavit filed by the state, page 36. Kindly turn to page 36, my lord. If your lordship looks at paragraph 2. But it said in order to the subparameter, respondent 4 fulfilled the criteria required for the post. Besides, respondent 4 was respondent 4 was the petitioner there.
Your qualification is PG diploma.
Qualification is there, but Tata itself was the diploma course, and that certificate was filed. The state has also admitted in para 37, Lakshmi kindly see. Para 37, page 37, para 3. It is further submitted that respondent number 4 was possessing all the requisite qualification for the post of vocational counselor. She completed her graduation in the year 1993, successfully completed her post-graduation diploma in social science from Tata Institute of Social Science in 1999, acquired practical knowledge in the field. As such, she was selected and appointed through the recruitment process as a vocational counselor by the selection committee in May 2001. And to work in the contractual basis, that is C/2, the series the government has relied upon. It is not out of place to mention here the applicant was enlisted in the panel awaiting list by the same body. The applicant means here is number 4. But the Honorable, they have filed a rejoinder, my lord, without serving a copy on us. A document was filed, Annexure 8, which was relied upon by the Honorable Single Judge. We also wanted a copy to be given to us. That says the certificate obtained by us is not a valid certificate, not a recognized certificate of the Tata. But we are not given any opportunity to file a rejoinder to that, to reply to that. But that certificate cannot take away the effect of it. Tata doesn't come forward to say, but my requisite qualification was verified by the authorities. But 12 years after, somebody files an application challenging the same.
All right. You are for the other party.
Yes, my lord. I am for the respondent 4, my lord. The petitioner is the request. My lord, what my learned senior has submitted is not a question of regulation, my lord. It is in the past 2001 an advertisement was made for 89 days contractual basis.
No, what were you doing for 12 years? 30 years?
No, my lord. I am not challenging not to 10 years, my lord. But the phrase advertisement, lordship, sir, Annexure 4. The press advertisement.
No. One minute. You are not challenging the appointment.
Yes, I am challenging the appointment which is made in view of the advertisement that of 25/10/2012. That is the advertisement. He was continuing. The appellant and the respondent for both are continuing as contractual appointment. They are continuing as a contractual appointment. In 2012, a fresh advertisement was made for regular appointment, vacancy arises. In view of that, that advertisement clearly speaks that that's why your lordship shall look to page 31, 32. Right? That is.
So they created 41 posts. They created 41 posts in 2012.
Let me submit. Under the Annex 4, lordships, the page 31. Annex 4.
Yes.
To creation of post in Regional Spinal Injury Center. Sir, I am directed to say that the government, after careful consideration of the recruitment of the Regional Spinal Injury Center, Cuttack, have been pleased to create the following 41 numbers of posts. This is the Vocational Council in serial number 5. There is one post, ma'am. So, lordship, let's come to next page.
Page 33.
Yes, ma'am. 32, ma'am. 32. The posts now created, except what amendments shall be filled up in the following relevant criteria and regulations of government. Para 3, the above posts have to be filled up in the transparent manner following the relevant recruitment rules, procedures, and provisions of ORV Act, whichever applicable. But the advertisement was there. In view of that, when the petitioner came to know that the opposite party number 2 is trying to engage the appellant, they have approved this honorable tribunal. Honorable tribunal passed the order. That order was not annexed to this appeal matter, but that was annexed to my writ application. So let's look to page 20 history writ application, where this honorable tribunal was held that any appointment should not be violate the para 3 of the advertisement. That will be transparent manner. But without making an advertisement, without making an interview, they have appointed, they have recommended the name of the appellant, and that has been approved by the government. That was challenged. That was made on 2/4/2013. That appointment was challenged before this honorable tribunal and subsequently transferred to High Court. And in that matter, the honorable single judge had this matter. And in his observation that the appellant, who was the respondent 4 in the writ application and has been appointed in view of the advertisement as 25/10/2012, does not possess the required qualification, and accordingly that has been the qualification required, that is a diploma from Tata Memorial Hospital, and that from the RTA Act it is obtained that the opposite party number 4, now the appellant possess that qualification is not equivalent to that. That was filed in the result paper. The copy had been solved, my lord. That's what my learned senior said, the copy not solved. It is not correct. The result copy was also solved. Copy was solved.
Sir, Annexure 5, let's me kindly see.
And thereafter the order was passed by the single judge. And single judge discussed all the aspects.
My friend didn't show that. Page 33. It says I am directed to say that government, after careful consideration of the recommendation of the selection committee constituted on the selection of eligible candidate for the newly created post, Regional Spinal Center Injury Cutter, serial number 10 is the present
What's the locus standi of respond before?
Beg your pardon, my lord?
Locus standi, respond before.
But their stand is, they have been appointed subsequent to the petitioner, and they say they should have been regularized instead of the petitioner.
Oh,
question of regulation.
They're also appointed as vocational counselors.
Yes, madam.
Yes.
I see.
They joined 9 months after.
Yes, madam.
I'm the senior.
In contractual basis, I was joined after that. It is admitted fact. But
Same
it's not
process.
not a question of regulation.
No, there are more posts or only one post?
Sir, only one post. I was selected.
But how will they engage?
That is exactly the question.
Oh, I see.
She was joined in a post which is not in existence. Now she is challenging.
No, my respectful submission. I have challenged the.
How did you get appointed?
Contractual basis, my lord.
On what basis? Because there's no post.
Only
Yes,
one
my lord,
post.
that was post, my lord. I am also continuing from 2002.
No, but against which post?
It's a
There's no
contractual
post.
April basis, my lord, then contract basis, my lord.
If you're continuing since 2002, then you can't come and challenge in 2013.
No, my
If you're challenging in 2013, on what basis did you get appointed?
My lord, my respectful submission, I am not challenging the appointment of 2001 made by contractual basis. She was continuing on contractual basis. I am also continuing on contractual basis. His appointment is prior to 9 months prior to my appointment on a contractual basis. But now the question is when the press advertisement was made in 2012 for regular vacancies. And I deserve qualification. She doesn't possess the qualification. And she was appointed, that was on the challenge. That is the question.
Anyway, notice, he accepts notice. Till the next date of hearing, there should be a stay of the impugn order. Right now, what's the position?
Continuing, man. I'm continuing.
All right.
But my respect to submission, even after the order of the contempt, the order has not been complied.
Yeah, that's right. Because this itself will stay, then contempt will automatically get adjourned. List on 17th August.
But interim order true.
That's what.
Great.
Item 36.
That's the impugned order, my lord, directs the government to analyze the representation. So, my lords, I'll withdraw this appeal.
All right. Counsel for the appellant seeks leave to withdraw the present appeal, disposed of the withdraw.
Item 37.
Withdrawn, my lord. 36.
He's withdrawn the appeal.
My lord.
Item 37.
Similar order.
Yes, please. Page 17. The input. Page 17.
No. He have issued notice in similar matters.
Yes, my lord.
Where is that? Rehabilitation assistance.
That is the rehabilitation. I have given that copy. My lord, your lordship fixed 30th August.
Where is that?
I have given that copy. Just now I have given. Sorry. In item.
What is that?
32. In item 32, I have given that copy.
When is that notice returnable?
30th August, my lordship.
30th August. No, there should be, there should be a stay in the meanwhile. Right.
Stay connected matter. Item 38.
None appears dismissed.
Item number 39.
One time for the removal of defect, my lord.
Item 39, my lord, is a state appeal. As this is also a first day disposal, my lord.
Item 39.
39, sir.
39. I'm sorry.
List on 26th April. Defects be removed in the meanwhile.
Item number 40.
My lord, item number 40 is same removal of defects one more time.
Same 26th April. Defects be removed. Okay.
Item number 42.
My lord, in item 42, my lord, as directed by my lord, 4/1/2023, my lord, the victim's parents have been made as the party here, my lord. One IA application has been filed by number 758 of 2023, my lord.
Plus, we have filed affidavit also pursuant to your lordship's last direction. Part of the prayer was addressed, and regarding compensation, my lord, I directed as to what compensation granted. My lord, since there is no provision under the statute, so Puri municipality has requested collector and my lord, so 30,000 out of CM's relief fund and 20,000 out of Red Cross, my lord, it has been paid, my lord. That we have, my lord, filed.
You filed an affidavit?
My lord, we have filed.
Where is that?
Only copy could not be served because
No, where did you file the affidavit? I don't think this is there.
No such thing. Right.
There's no affidavit here.
5 minutes. May not have come and record file.
Have you implicated the parents?
My lord.
This IA number 758 for the reason stated there. The application is allowed. And the persons in the schedule are implemented as co-petitioners 2 and 3. The consolidated cost titles be filed within 1 week. The consolidated is already filed, is taken on record. All right. Council of the Pune municipality states that he has filed an affidavit on.
That's 6/3, my lords, 2020. 6/3.
6/3 be placed on record. You have a copy?
Just now served, my lords.
Just now.
A copy has been served on council petitioner. List on. 24th July.
Item number 43.
Item 43, prefer to each time to file rejoinder. As some days back, object party number 3 has filed the counter.
Rejoinder to be filed. What's the matter about?
This is I'm not the intervener. My application is at page flag B. Here is a question of construction of a road in both NSC, and both NSC already has filed a counter. Now I am the party whose land is going to be acquired. Now I have agreed to that. There are 3 plots I've agreed. I am the donor. Now NSC is playing not playing fraud and not allowing the road to be constructed. That is opposite part number.
And for the NAC?
No,
who appears as NAC?
As opposite part number 3. He has already filed counter.
Mr. Zaffarullah has.
Yes, my lord. I am appeared for opposite part number 3.
They have filed counter. In counter, if your lordship will see page 4, they are counter by OP3.
We don't have a counter by OP3.
Unless it has been.
They have given a table.
We don't have a counter by OP3.
It has been filed on 20th of.
You have a copy of the counter?
Yes, I have the copy of the counter.
Oh, a counter affidavit stated to have been filed by OP number 3. We brought in record. Counsel for the petitioner seeks time for rejoinder. Seeks and is granted time to file rejoinder before the next date. List on. May.
My IA may be allowed intervention.
All right.
Flag B.
14311.
14312. 11.
Where is that? That's not here.
That may be allowed. Flag B.
311 only. It's 14311. For the reason stated, the application is allowed. The applicants are permitted to intervene in the petition. Right.
Item 40.
Date given, na?
16th. Item 44.
My lord, in the Odisha Commission for Protection of Child Rights, all the 6 spots of members are lying vacant, my lord.
Yes, my lords, give me a week's time. I'll get instructions. Does that?
So everything has.
My lords, may post it tomorrow, my lords. My lords, may post it tomorrow. I'll get instructions.
At the request of Mr. Ishmael, list on. (21st March).
Item number 45.
May it please your lordships. But this writ petition raises a short issue of law with regard to the constitutional validity of an amendment made to the Income Tax Act in 2019. Very briefly, and the matter is in a very narrow compass. In 2013, the Income Tax Act was first amended by introduction of section 115.
1 minute. Morning, I'm requesting my seniors to grant some because counter region, everything is not ready. I request fixing on other date so that I will assist to Lordship in a proper manner. I'm already in the morning. I'm requesting, Lord.
No, I
understand the difficulties. My senior Lord, he also had to come here to matter.
The pleadings were completed 7 months ago. By August 2021, the issue is in a very narrow compass. I told my learned friend that I would be citing 1 or at the most 2 judgments. And I told him, finally, I've come all the way here. Kindly permit me to argue this matter.
I'm sorry.
I'll take less than half an hour. And if you still have difficulty at the end of the day, then you give your reply tomorrow.
He'll find more difficulty after you argue.
No. That is not my problem. Lords, may I only say this? Then that is not difficulty, my lords. He's aiding the cause of justice then. If he surrenders to me in a lighter way. Therefore, I would respectfully submit, let me complete my argument today. If my learned friend still feels there is some need for his making further preparation, my lords, this is a matter where the pleadings were completed about 8 months ago. Therefore, there is no justification at all for an adjournment. If he still needs time, then let him give his reply tomorrow, my lords. There can't be any problem with that. He can get ready in a day's time. There's no problem at all. In fact, this date was fixed, my lords, quite some time back. So it should not come as a bolt from the blue or as a surprise for him.
No, actually, it's come up because we are listing all the older matters.
Right.
The previous hearing, this was supposed to be listed on 8 September.
Right.
I think that date probably was not listed.
Right. Correct.
So this has come up in the list after that.
I understand. Very well.
So he may not be aware of it, and also the intervening holidays and all
I understand. But the issue is a very narrow one.
What we can do is you can file your written notes of argument.
Right.
And we can even have a virtual hearing in case there's any difficulty.
Lord, sir, the matter is very important for my client. So that is why a personal hearing would be greatly appreciated.
No, fine. We have no issues of that.
So I was only wondering if I could complete my side of it. 20 minutes to half an hour, not more than half an hour. And then the matter can stand over. If my learned friend still feels that tomorrow is not long enough, then my lords will consider giving a date. But my lord will see what a narrow, my lords, conspectus the matter falls within. Whether you can have a tax on buyback of shares, my lords, in respect of quoted shares. They made a provision for it in 2013. And they said there shall be a tax which is levied only in respect of unquoted shares. There's a very good reason for that and for distinguishing between quoted shares and unquoted shares. Because in unquoted shares, the promoters are allowed to participate. And therefore, the persons who decide on whether there should be a buyback or not are the persons who benefit from it. And so the legislature felt that in such a situation, the buyback is usually resorted to as a means of tax avoidance. Instead of paying dividend, you distribute your money by means of a buyback. In sharp contrast, in respect of quoted shares, under the SEBI rules, the promoters and persons in control of the company, these are the exact words used in the SEBI regulations,
cannot participate.
Cannot participate. So therefore, they would never take a decision, Lords, only for the purpose of tax avoidance, because they don't get the benefit, number one. And the benefit goes only to other non-promoters and non-persons who are not in control of the company. So they are actually parting with a sizable slice of their net worth in favor of third persons. So they would never do it only for the purpose of achieving some advantage in the form of tax avoidance. So whenever there is a buyback in respect of quoted shares, we can almost take it for granted that it is fully justifiable on grounds of commercial expediency and market requirements and so on, capital requirements, renovation of the capital structure and so on. So therefore, the extension by amendment of this section in 2019 to cover buybacks.
Yeah, the only other difficulty also is that the regular bench, we are not the regular bench.
I see.
My bench partner who normally sits is on leave today and tomorrow.
And tomorrow as well.
So that's why. Because again, then we'll have to reconstitute. Suppose we hear your arguments today. And then, because tomorrow is Friday.
On the contrary, it presents me with a welcome opportunity. The same bench is available tomorrow.
No, so tomorrow is a Friday. That's why. We'll have all the break benches and all of that.
Oh, I see. Because I will take less than half an hour. But I don't think my learned friend will take more than that. There's only one judgment on this. Only one judgment of the Supreme Court, which I would like to cite.
I know, but it's
so it makes it totally arbitrary.
Yeah, it's better if the regular bench sits also. That's nice.
Nice. Very.
You say,
could it be on 3rd or 4th April? I'll be really grateful.
All right.
This is a matter which will require a personal hearing. That is why we are troubling, my lords.
What about 12th April?
3rd, 4th, and 7th, my lords, are
the convenient dates.
Exactly, for me. If it is not inconvenient to the court, I
Third is a
would be
Monday.
glad.
So anyway, so
7th is a holiday. Yes. Oh, yes.
4th is Tuesday. All right. Take your chance on 4th. You say, I'll just say this, written notes of arguments be filed by both parties.
Very well.
List for hearing on 4th.
Very well. This is the narrow ambit of the controversy.
All right.
So there are grave anomalies and iniquities which arise if you extend this provision of buyback to quoted shares.
All right.
Because ordinarily the situation of resorting to a buyback for the purpose of tax avoidance would never arise in respect of quoted shares.
All right.
So at the last argument which we are putting forward is, if my lords feel that this is not a case for striking down, then at least give us an opportunity to show that there is no tax avoidance issue here at all. And the buyback is fully justifiable on commercial grounds.
Lord, I am sorry, my lord, I am 12 and 13. Your lordship dismissed that, but actually, my lord, we have already filed the requisite. We have already, 13 and 14, I was other court, my lord. So your lordship dismissed it. We are already sure. Notice has
No,
been
but
already.
noting here is something else.
Yes, my lord. In 25, 2022, I have requisition filed, my lord. I have checked it, my lord, the record, if not both the matters. I have first issued notice to Bhubaneswar address, nobody is found. Then I got after the address of the Calcutta, my lord, the director address. Then the director address second notice has been issued. If it's not been, my lord, receiving, then I may permit me to paper publication. Lord. So, but it is a issue. A lordship has formulated the question. So, far the interest whether 234 A, B, C is leviable, Lord.
No, but have you seen the noting?
Yes, I have seen the notice.
Notice could not issue because requisites not yet filed.
For the Lord amendment, for the IA, your lordship, but that confusion, Lord, I also face that confusion. That is an IA.
Correct.
But so far as the main issues, Lord, main.
No, you can't have requisites.
No, IA is filed later on for better question of law. IA is filed later on, Lord. That is the Lord confusion. I have not played. Lord, if we keep it on other day, Lord, tomorrow at least, Lord, I'll.
Or just in this 12 and 13, Mr. Satpathy states that requisites are filed on which date?
Lord, 25, 2022.
25, 22?
Yes. In Calcutta address. Receipt is with me, Lord.
No. We issued notice on 9/12/22. That's why it's correct only, sir. The order passed is correct. The order passed is correct.
9/12.
Sorry. We heard the matter on 9 December. You're talking of May.
Yes, 9/12. Lord, I will not give permission so that I paper publication on this issue. Lord,
No.
They are sale companies, sale companies. They are not available. Lord.
Sorry. Yes.
Your lordship, my appearance may be noted. Your lordship may.
All right, appearance.
Order 46.
Both the matter, Lord.
Yes.
46, my lords. I'm appearing on behalf of respondent number 5. I've already filed the counter. Lordship, I'm filing the counter affidavit. I've already served on the counsel for the petitioner. Lordship, your lordship.
Lordship, today I have received the copy of the counter.
I have also filed the counter.
All right, rejoinder be filed for the next date.
Only one thing I may draw your lordship's kind attention, that the interim order dated that whether that interim order has been complied or not. Your lordship has directed to deposit 20% of the tax. Your lordship has directed by the order dated 3rd August 2022. Your lordship has directed 20% of the tax as determined by the assessment order is dated so and so passed under 73 within a period of 4 weeks from today. Your lordship, the petitioner has filed one IA that he has deposited part of the amount and part of the your lordship paid for installment. Your lordship also we have filed on one IA. In that IA, in identical matters here in this case, your lordship, the 73 order, assessment order, adjudication order has been challenged. And at the time of challenging the adjudication order, the petitioner has paid to declare the constitutional validity of section 16(2)(c). So in identical matters, your lordship, when your lordship as the coordinate bench has admitted all those matters, in all those matters, this honorable court has directed to deposit 20% of the tax and interest. In this case, it has been excluded. Interest has been excluded. I have cited many of the orders in my IA that in all the identical matters, this Honorable Court has directed to deposit 20% of the tax and interest. So, Your Lordship, for modification of that order to deposit so far as 20% of the interest amount, I have filed this IA. My IA is pending, Your Lordship. I have filed counter. Now, Your Lordship, the PT, Your Lordship has directed 20% of the tax. Even that amount has not been deposited on the place of the IA filed by the petitioner, Your Lordship. Part of the amount has been deposited and he has paid part of the next further part in installment, Your Lordship, which should not be granted, Your Lordship. Your Lordship may decide those two IAs.
By now, have they paid the 20%? They have not yet paid.
Your Lordship, pursuant to the interim order, 3rd August, when there was a direction to pay the amount, we filed an IA for modification of the order, and simultaneously my learned senior also filed an IA. Your Lordship may kindly see the last order. Your Lordship, in the coordinate bench, had passed an order directing that both the non-applicants file reply to the said IAs. So the IA is now pending consideration before Your Lordship, and the non-applicants, that is the petitioner, will file a reply to the IA filed by the department and vice versa. So that reply is yet to be filed by both.
That's all right. We're now on that compliance with that order of 3rd August.
We have filed an IA for modification of the said order, Your Lordship. Your Lordship, under 16(2)(c).
Filed it on 22nd August.
Your Lordship knows under section 16(2)(c), the issue is that I have already deposited the entire money and the ITC that I had availed had been reversed. This case relates to the case where the supplier is OCL, Your Lordship. OCL was before the NCLT and liquidation.
No. How much time had you sought? You filed this application on 30th August, is it? 22nd August?
Yes, Your Lordship.
You wanted 10 monthly installments.
Your Lordship may kindly permit, I'll file a reply to the said IA as per Your Lordship's order.
If it was 10 monthly installments.
Yes.
How much have you paid? How much remains to be paid?
Your Lordship, I've paid 22 lakhs some odd.
No, how much remains to be paid?
I'll take instructions on that, Your Lordship.
If you've not complied,
then... 6 of the IA. Page 6 of his IA. He has deposited only 10 lakhs.
No. Pursuant to that, I've also deposited. I'll take instructions on that, Your Lordship.
1.63 crores.
This has to be deposited.
Page 6, Your Lordship. At paragraph 8, 1.63 crores, Your Lordship. And with great respect, Your Lordship.
May kindly
Your Lordship has not admitted any matters. So with great respect, Your Lordship, because Your Lordship, it is the assessment order. Adjudication order has been challenged here.
Even otherwise, Your Lordship, under section 107, I am only required to pay 10%. Since I have come challenging, Your Lordship has observed the same in Your Lordship.
The adjudication order has been challenged, which is appealable.
Your Lordship has categorically noted the fact in the said order, Your Lordship, in 3rd August. Even though there was an argument that appeal lies, but since I have challenged the constitutional validity, Your Lordship has entertained the matter and admitted the same.
Then you've not complied with that interim order. So,
Your Lordship may kindly grant me 1 week's time. I'll take instruction and then file the reply as per Your Lordship's last direction.
Your Lordship, so far as the mine is concerned, very limited prayer. Your Lordship, in identical matters, Your Lordship may kindly turn to my IA.
That was passed in August.
Yes.
Then in March.
Yes, Your Lordship.
So in between, there have been 7 months.
Your Lordship.
Even if you went by monthly installments, if you're giving yourself monthly installments, you should have paid much more than.
Your Lordship, I'll take instructions on that. Your Lordship may kindly grant me 1 week's time.
You see, this court had on 3rd August 2022 grant conditional stay of the impugned order dated 12th May 2022, requiring the petitioner to deposit 20% of the tax. Just put down this IA number. IA 11435 of 2022. The present application has been filed stating that the petitioner is in financial distress and that 10 monthly installments should be permitted to pay the balance amount of $1.53 crores. Stop. This would have approximately worked out to 15 lakhs per month. Paragraph. The present application was filed on 22nd August 2022, which is more than 7 months ago. If a sum of rupees 15 lakhs were to be paid per month, the petitioner should have deposited by now at least rupees 1 crore as part of compliance with the interim order. Full stop. It is made clear that if the petitioner does not deposit, the entire balance sum of rupees 1.53 crores.
That 1.63.
Your Lordship,
After deducting
After
10
deducting, it's 1.3.
further, your Lordship is the
Your Lordship, may kindly
further deposit of 1.63 crores.
1.63 crores, which works out to approximately 16 lakhs per month. It is made clear that if the entire balance amount of rupees 1.63 crores is not deposited by the petitioner on or before 1 month's time can be given maximum. 17th April 2023, the interim order passed by this court shall stand vacated. Full stop. The application is disposed of.
Well, it's my counter
Your Lordship, may kindly
taken on record.
Say
My Lordship,
12015/2022. This is an application by the department seeking modification of the order dated 3rd August 2022, by which the court had granted conditional stay to the petitioner, subject to the petitioner depositing 20% of the tax demanded.
Tax and interest.
only tax. Only.
The modification is that it should be 20% of the tax and interest and not merely the demanded tax. Paragraph. Considering that the petitioner has already pleaded financial hardship and has not been able to still comply with even the aforementioned order dated 3rd August 2022. This court is not inclined to accede to the prayer made in the present application. It is accordingly dismissed.
Good.
Then we say
my counter on behalf of the
rejoined to be filed
department.
for the next date. List on 2nd May 2023.
The counter affidavit on behalf of the department, Central GST, my lords, respondent number 5. Lords, I have just handed over to my learned.
That's what we said, rejoined before the next date. Yes.
Your Lordship. I have also filed counter.
All right. After lunch.
Supplementary list item number 47.
May I please, Your Lordship? My refund application has been rejected on the ground of delay that fell on COVID period against the circular of the CBIC circular, my lord.
The dates have to be changed.
My lord, my refund application was 23rd April 2021 and the CBIC, my lord, last paragraph, my lord.
Past similar orders.
Your Lordship, it's an appealable order. Refund.
I know, but we have passed similar orders.
Okay.
You say the impugned order dated 24th May 2022. Passed by the superintendent.
My lord.
Central tax, GST and central excise, Rourkela, on the ground of the refund application, dismissing the refund application filed with the petition on the ground of delay, has obviously not taken note of the notification number 13/2022 central tax dated 5th July 2022 issued by the CBID, Central Board of Indirect Taxes and Customs, Department of Revenue, Government of India.
Your Lordship, that circular has been of 5/7/2022, but the order has been passed on 24/5/2022. Prior to that.
Could not have, yeah. You just say could not have. By the issuance of the said circular, it is now clear that the period between 1st March 2020 and 28th February 2022 has to be excluded while computing the limitation. On that short ground, the impugned order is set aside and the refund application is restored to the file of the superintendent for being considered afresh in accordance with law. The matter will be listed before the superintendent on 17th April, on which date the petitioner will appear through an authorized representative together with a downloaded copy of this order. The petition is disposed of.
Item 48.
Kindly permitted to
Dismissal is withdrawn.
Item number 49.
Item number 49, 50, 51. These are against that first appeal order. Notice has been issued. Your Lordship, some more time to file.
It will be counsel for the state seeks and is granted 8 weeks time to file the reply. Rejoined up for the next date. Interim order to continue. 12th October.
Your Lordship, item 49. It is against the first appeal order. But Your Lordship, it arises out of my refund rejection. Refund rejection was only that there's a short ground involved, that the export duty that I am claiming refund, I am saying that it is exempted goods. So I am claiming refund. The first appellate authority has taken into consideration a decision of the advance ruling of Goa. Subsequently, Your Lordship, after the first appellate order, that is 19/8/21, on 29/2021, there is a CBIC circular that says that the exempted goods refund will be allowed when claimed. The same has been challenged in the grounds of appeal before the learned first appellate authority. The same has not been taken into consideration. So all I pray, Your Lordship, is to be relegated to consider the said CBIC circular, because that was subsequent to the first appeal adjudication order, refund rejection order.
So I have not examined.
Your Lordship, on last date, Your Lordship directed to file a counter affidavit.
Yes.
Since this is the only ground involved, I request Your Lordship to kindly send it back. And in terms of the CBIC circular, my reply, Your Lordship may kindly see page 84 of the writ petition.
This is 23048.
Sorry?
49 or 50?
49, Your Lordship.
22984.
Yes, Your Lordship. Page 84. May I please, Your Lordship? Your Lordship, the last paragraph. At this juncture, the appellant would like to bring to your kind notice that CBIC in its 45 GST Council meeting address the said issue by taking an in-principle decision that the refund will not be allowed only in case where export duty is actually paid. In case the export duty is not payable or exempt, the refund cannot be denied. Pursuant to the said council meeting, CBIC by its circular dated September 28, 2021 has clarified the above issue. Relevant extract of the said circular is reproduced hereunder. And Your Lordship may kindly come to the impugned order at page 93, Your Lordship. The middle paragraph. Second paragraph. However, on verification of the reply attached with RFT 9, it is found that justification provided are not satisfactory since the exported goods iron ore fines is mentioned in second schedule of export tariff appended to the Customs Tariff Act, and thus the goods involved is subjected to tax. It is a settled law that nil rate of tax is also rate of tax, and once it is mentioned in the tariff, the goods is subjected to tax. Nil rated tax does not necessarily mean that the goods are exempted. So without taking into consideration the very circular that says that once it is nil rated, so it will be exempted, the said order has been passed, Your Lordship.
I think, Your Lordship, on this issue, this Honorable Court has already passed some order so far as that nil rate that court has passed. Your Lordship, a short date. Either Your Lordship, it may go back for consideration that.
She only wants
because I think I remember so far as Your Lordship, some order has been passed also.
Anyway, there's a circular. She's only
Your Lordship, by cognizing that circular, this Honorable Court has passed the order in favor of the petitioner, Your Lordship. What I remember, Your Lordship.
The present appeal, a present petition challenges an order dated 31st May 2022, passed by the Additional Commissioner of State Tax (Appeal) Territorial Range Baleshwar. Rejecting the first appeal filed by the petitioner.
Your Lordship, I think let it be urgent to Monday. Your Lordship, I can produce that order. This Your Lordship has passed one order. So far as this nil-rated tax is concerned, my Lord and Senior also, Mr. Kaur, is well acquainted with that because he has done one identical matter. Mr. Agrawal, Your Lordship, he has done one matter.
Agrawal was arguing from Delhi, Milods.
Your Lordship,
allowed those.
Your Lordship was passed one order. I am sorry, I could not because I have.
All right. You just say this item 49 at the request of Mr. Mishra. List on Monday will be very crowded. 15th March.
Your Lordship, just because it is in favor of the petitioner, but the detail can be.
Obliged, Your Lordship.
All right. 15, 51, 12th October. Right.
Item 52.
52 Milods, I've received a counter Milods. This needs some time to file a rejoinder.
Rejoinder for the next date. Interim order to continue 12th October.
Item 53.
Your Lordship, 53 for
same. 8 more weeks to file counter rejoinder for the next date. 12th October.
Item number 54.
May I please, Your Lordship? Just now I'm filing the rejoinder, my Lord. I have already served copy on state. Lord, here the matter. The petitioner's proposal for on-shop license, there was a public notice, my Lord. That public notice, my Lord, no objection was received from any quarter, my Lord. That Annexure 2, Lordship will find page 69, Annexure 4. Page 7 is relevant, my Lord. However, the proposal is laid down under Section 20 and Odisha Act and read with Rule 31, 51(6) Odisha Rule. Public notice inviting objections were issued by the auditor so-and-so in Odia and English language. Fixing the last date for filing of objection is 18/6/2022. In response, no objection has been received from any corner. Acting the proposal of the petitioner was processed and recommended to the government. Then, Lordship, the government rejected the proposal on the ground of existence of an aided education institution at a distance of 680 meters away from the proposed place. Then, that Annexure 7 was quashed by Lordship. That page 82. Because it was a non-speaking order, my Lord was pleased to quash the matter. That by the Annexure 8, Your Lordship's order, remanded the matter to the government to consider afresh, giving the opportunity of hearing to the petitioner, my Lord. In course of hearing, my Lord, I had placed the judgment of Your Lordship, where my Lord has decided any objection filed after the period of 15 days that has not to be considered and summarily rejected. The judgment I have relied upon and produced before the authority, they have reflected that this judgment has been produced by the counsel for the petitioner, but while passing order, they have not taken a consideration. Then the impugned order, my Lord, that is Annexure 9. On that score, my application has been rejected. Only point, my lord. Your lordship's judgment I have annexed. That is annexer 11, page 93. Only for the last operative portion I am reading, my lord.
The
Your
improved
lordship's
order at
page 99.
85 page.
No, page 99, my lord's order I am reading, my lord. There is also merit in the contention of the Lord and Council for the petitioner that Srimati Malati Tudu and Jagamona had filed their respective objection to the public notice at so and so, respectively, which were after the expiry period of objection period of 15 days provided under section 20 of the Orissa Excise Act 2008, read with rule 31A of the Orissa Excise Rule 2017 under rule 33(2). Any objection received after the aforementioned period ought to be rejected. In this present case, the public notice was issued on 20th July 2022 and objection had filed on 12th August. In plain that the objection filed were belated ought to have been rejected, submitted. So this judgment has not taken into care of by the government, though I had produced the same and they have rejected my application once. Lordship may see the objection filed by the college authority. That is page 92, annexer 10.
No, what do they say in the counter?
Same thing. Says
we have
only
justified
680 meters. Lordship knows the 500 the restrictive distance fixed under the rule 26. If the less than the 500 meters, the government has power to relax. But here is a 680 meters, not within the restrictive distance. That after the objection period, 2 points I have raised.
The title in the cover sheet you said counter affidavit.
Oh, my lord, I am extremely sorry. I'll rectify that.
Rejoinder
It's a rejoinder.
Where is the counter?
Counter filed on 6th of this.
I don't think it's come on record, sir. There will come on record. Say that
I have the
counter affidavit filed on 6th March 2023. We brought in record. The rejoinder affidavit has already been filed today by counsel of the petitioner. List on
Monday, my lord.
No. Is there any 31st March?
31st is the last date. Same problem, my lord. My lord has specifically directed by 3rd January the order should be passed. On 3rd January they passed the order. 31st is the last date.
What do you say?
My lord, in the first order, your lordship has directed that this order cannot stand because there is no reason of rejection. Subsequent order, which is impugned of this
objection of that Mahila college, was received after the deadline.
That is there. And he is saying that my decision has not been taken care of by the decision cited by him has not been taken care of by the government. Your lordship may direct back for to reconsider.
Yes.
That is the only.
All right. It is pointed out in the counter affidavit filed by the state that objections were received from a Mahila college regarding the distance of the location of the proposed on-shop being
680 meters.
At a distance of 680 meters from the said college. Counsel of the petitioner points out that in the first place, the said objections received beyond the deadline. And secondly, that
annexed 10, my lord.
That decision may kindly be taken on.
That there is a decision
which
by
is relying upon.
Give me that.
My lord, your lordship said
no.
WPC 30340/2020 Gitanjali Sahu versus State of Orissa.
Yes, that is annexer, my lord. 11. I have given page
24
93.
November 2022. Passed by this court.
Earlier order was annexer 8, my lord.
Annexer 8, is it?
8 is the earlier, your lordship's earlier order, page 83.
No. Where I said beyond the period you cannot accept.
That is
Your lordship's order, that is annexer 11.
Page
Page 93.
Right. You see,
Gitanjali Sahu versus State
relies on the decision dated 22nd February 2021 passed by this court. And it petition civil 30340 of 2020, bracket Gitanjali Sahu versus State of Orissa, where it was held that objections received beyond the deadline cannot be considered. So it is pointed out that despite this decision being brought to the notice of the Excise Commissioner,
Excise Government Matter, Principal
Secretary, Department of Revenue, Excise,
Excise.
It has not been accounted for while passing the impugned order. Dated 2nd January 2023. Paragraph. The perusal of the said impugned order reveals that the said decision in Gitanjali Sahu Sutra has not been accounted for by the Secretary, Department of Excise, Government of Orissa. For stopping that view of the matter while setting aside the said order, the matter is remanded to the Secretary, Department of Excise for a fresh hearing of the petitioner on a date to be informed at least 2 days in advance, and a fresh reason order to be passed on or before 27th March
of last month,
2023. The petition is disposed of. A copy of this order be sent to the Secretary, Department of Excise. Forthwith.
Item number 55.
My Lord, your Lordship has directed the State Council to find out the vacancy where this petitioner can be appointed, my Lord. Twice, your Lordship, on last two orders, your Lordship have directed.
My Lord, the instruction which we have received from the CDPO Patamundai with reference to the subject cited, I am to state that there is no vacant post of Anganwadi worker at Bishnupuru Anganwadi Center. Repati Behura is working as a Anganwadi worker.
That instruction on the last date they placed, my Lord, your Lordship directed that in the ICDS project, Bishnupur Anganwadi Center has been filled up by the opposite party number 5. Therefore, your Lordship directed under the Patamundai ICDS, is there any vacancy for appointment of the petitioner? That your Lordship directed. This instruction was placed in your Lordship's last order.
Please wait what I am reading the next para.
Yes.
There are 2 number of Anganwadi workers vacant under ICDS project Patamundai. 1, Pandudolo, 2, Bachara. As per guidelines for selection of Anganwadi worker by letter number so of W&CD Department, Odisha, Bhubaneswar, applications will be invited for selection of Anganwadi workers for women residing in the said Anganwadi center area. This is
which means she can't be accommodated.
Yes.
My Lord, that if your Lordship directed, she can be accommodated because she has been deprived of.
But that will go against the rules. The rule prescribes that she must be within that area. That is what that
then
is
you
the
lost
instruction.
here on merit, my Lord, whether the appointment of that respondent number is in accordance with law or not. I have a right to be considered or not. 6.
A written instruction dated 9th March 2023 has been produced before the court by Mr. Monty Learned AGA to the effect that in respect of 2 vacancies in the post of Anganwadi worker under the ICDS project at Panduhota and Bachara
under Patamundai
ICDS project, applications will be invited for selection of an Anganwadi worker. So in other words, the stand taken by the state government is that the present appellant cannot be accommodated in either of the said vacancies. Paragraph in that view of the matter, the appeal has to be heard on merits. List for final hearing on.
You lost a fixed date, my Lord.
17th April.
April.
17th.
17th.
Item 56.
May I please, Your Lordship? Your Lordship was pleased to issue notice in the matter on 20th of September 2022. This is regarding selection of Anganwadi worker. Now, the present petitioner was selected as the Anganwadi worker in respect of the center in question. She was on maternity leave and thereafter she wanted to join. However, some of the inhabitants of the locality, they resisted. I approached the authorities to provide me protection for the purpose of discharge of my duty. Since there were so-called notices, I moved this noble court by filing a writ petition that instead of giving me protection, so-called notices are being served. Now, my engagement was challenged by the present private respondent, that is respondent number 5, in a writ petition. That writ petition was heard and disposed of, relegating in matter to the collector on the basis of submission made by the Learned Counsel for the state before the notice days. Now, therein, the state government took a stand that my selection is justified. However, the matter was relegated because it has a forum of appeal. As per the provisions of the guidelines which has been issued, the ADM is the appellate authority. The collector proceeded to decide the issue. Now, the collector relies upon at page 20, my lord, Annexure 6, on a report of the sub-collector, which was never provided to me.
On a committee. On a committee, finding was there, she doesn't belong to that area.
Let me just make my submissions. On one hand, in the beginning, they say I belong to the area. They select me. In the writ petition, they try to justify that I have been rightly selected, and that is therefore I have taken ground. I'll point out to your lordship so far as this appeal is concerned. Now, this collector, my lord, your lordship will find from Annexure 6, page 20, my lord, last 3 paragraphs, peruse the documents placed in the file, also gone through the joint inquiry report of the sub-collector Katak Sadar. Then the finding has been recorded. This report had never seen the light of the day. This was never provided to me, or nor I was given a chance to contradict it. I challenged it for this noble court in a writ petition questioning this order. Now, that has been dealt with by the Honorable Single Judge. Your lordship will kindly find
Page 25.
From the impugned order, 2 aspects the Honorable Single Judge has said. Since on the earlier occasion the matter was relegated to the collector, so therefore the collector is justified in adjudicating. And so far as this report is concerned, since it has been done by the sub-collector, so therefore that has been accepted by the Honorable Single Judge. Your lordship will see in paragraph 2 of this writ appeal, I have raised 3 points for your lordship's kind consideration. That is, 1, even assuming, my lord, it was relegated to the collector, it was the duty of the collector to send it to the ADM for adjudication, because as per the guidelines they have set out, this is their own guideline. The ADM is the authority so far as appeal is concerned. So therefore, the adjudication by the collector is per se without jurisdiction, because he is only having domain over the urban area, not with regard to rural and other areas. Secondly, but the state government having taken a stand to the effect that my selection is justified in the earlier writ petition, whether could have taken a stand that no, I don't belong to the area, so therefore I should be disengaged. And issue was not that. Issue was some persons prevented me from discharging my duty. Therein it was incumbent on the state and other machineries to provide me protection, be it a small job of Anganwadi worker. Now, third point that I have raised is the collector deciding the issue by relying upon a report which was never provided to me to contradict it. But you have selected me saying that I belong to, because your lordship knows during the process of selection, as per the guideline, scrutiny, inviting objection and everything is made. And thereafter the matter is decided. Now you decide and you hold that I belong to the Anganwadi center area and then select me. Now, my lord, later on you turn back and say, no, I don't belong to the area on the basis of a subsequent report. Once you rely upon a subsequent report, my lord, I deserve a hearing so far as that report is concerned, and I should be given a chance to contradict. That was never done. So therefore, in this background of the matter, my humble submission would be the order suffers from 2 defects, namely for want of jurisdiction as per the guideline. Secondly, for want of natural justice, my lord. That my lord, I have not been provided with an opportunity. These are the points I have raised, my lord, in paragraph 2 of the writ appeal for your lordship's kind consideration. And on 29, 2022, your lordship was pleased to call upon the other side. The matter is a year-old matter considering these points.
Your response number 5.
I'm opinion number 5. Your lordship, my submission before lordship is 2-fold. Number 1, in reply to my friends, the revised guideline, appeal lies to the collector. May I place it? That is the revised guideline of 2007, your lordship, that in case of a disengagement, collector shall be the appellate authority in the hearing of a disengagement of Anganwadi worker. My friend has been disengaged by the order of the collector, which is the assault before my lord, single judge. And your lordship, the second one, a committee first, by filing a residence certificate, forged one, she got an opportunity, which was a challenge. A committee was constituted. In that committee, sub-collector, CDPO, BDO, and also all those 7 members were there. They constituted a committee. They inquired into. It has been held that she doesn't belong to the area in which Anganwadi workers is situated. That has been dealt with by His Lordship at running page 25, Your Lordship. May I place it, Your Lordship? Peruse the documents placed in the file. Also gone through the joint inquiry report of the sub-collector Kotak Sadar. It transfers from the said report that Srimati Mamina Rao, this petition doesn't belong to the said service area, that is Vidyadharpur so and so, in which she has been selected. It is also clear from the survey register that she belongs to Satyanagar Sahi and not Vidyadharpur Nuasahi service area in which the center is situated. The villagers in the meeting held on so and so had vehemently opposed her selection and appealed before the inquiry officer for selection of Anganwadi worker from the service area of the village. In view of the above findings, it is clear that the engagement of Srimati so and so, this petitioner, goes against the stipulated norms and the guidelines for selection of Anganwadi worker issued by the government. It is hence ordered for her disengagement from the post, for which, as she is not a resident of the service area, and the sub-collector Sadar, CDPO Cuttack City may start a selection process afresh to fill up the post of Anganwadi workers, Vidyadharpur Nuasai, strictly in conformity with the guidelines of the government. That's all.
And just let me just clarify one thing. My listener, with all humility, I may say, has confused between the challenge to the engagement and a disengagement. Now, so far, the provision which my listener just now placed before your lordship is with regard to disengagement, which is provided in clause 4, which said the appeal is before the collector. What was challenged for reasonable court and relegated to the learned collector was my engagement as Anganwadi worker, not disengagement. Why I am making this thin line of distinction is, so far as the engagement is concerned, that is being, the appeal is being provided in, my lord, clause 2I of the guideline. That says that ADM will be the appellate authority for hearing complaints regarding selection of Anganwadi worker for tribal and rural projects and urban projects. Collector shall be the appellate authority in case sub-collector ADM have approved the selection as per paragraph G and H above. So therefore, so far as the selection challenge is concerned, it is the ADM who is the appellate authority. It is only when post facto, the selection and engagement, a person gets disengaged, there, my lord, the collector's domain comes into picture for the purpose of entertaining an appeal. So this is the distinction. So it's an engagement which was being challenged. So therefore, ADM is the authority. That is what is explicit in the guideline in terms of clause I of Roman 2 of the guideline. My litigation is placing clause 4, which is in respect of disengagement, my lord. So my engagement was challenged before this noble court directly in a writ petition, and that was relegated to the land collector for adjudication, which in my humble submission, even assuming that it was relegated, it cannot cloud jurisdiction on the collector. So the collector in all fairness should have sent it to the ADM saying that no, I don't have jurisdiction to entertain, and ADM should have decided it. So therefore, this order is suffering from want of jurisdiction, number 1. And so far as this report is concerned, my lord, I beg to humbly submit, howsoever incriminating it may be against me, I should be, because this is a report post facto my selection, continuance, and I took maternity leave only when I was prevented. And even my prevention, when they served a so-called notice, I moved this noble court. My service was protected by this noble court in a writ petition. Because he preferred a writ petition and it was relegated.
But you're not answering the question of your residence. Where are you residing?
My lord, I am residing there only. My lord, your lordship will see That is the adjudication and that is the stand of the government in the earlier writ petition, my lord. In the earlier writ petition, government supports my residence, my lord. It is not that the government doesn't support. So therefore, in this background, your lordship will see.
Who's for the government? Let's see. What is your stand?
My your lordship, page 20, the order filed by the collector, that is in pursuant to my lord's direction in WPC number 105452 of 2007. There your lordship had directed. Sorry.
No.
There your lordship had directed that opposite party number 4 to file an appeal for the collector. Accordingly, she has filed an appeal, and in compliance to my lord's direction, the collector took up the appeal. Even if that ADM admitted fact as per the resolution, ADM is the appellate authority so far as selection is where is challenged. Or so far as termination is the collector. Here, my admitted fact, this selection was under challenge.
No. What is your stand on the residence of the
residence? My lord, that counter is not with me, but the previous counter. But so far as that from the appellate authority's order, it is clear that he does not.
What is your stand, sir? Is the stand that she's part of this, the place where she's residing?
But that counter is not
within the.
Yes, ma'am.
No, that's the main objection raised.
Yes, ma'am.
He's on who should be the appellate authority, whom should it go to? Yes, on that point. The point he's making is on merits. She doesn't satisfy the residence requirement.
If I'll take instruction to that if she does not, yes, ma'am.
The entire elaborate exercise, sending it back to the correct authority, all that will be meaningless.
Yes, ma'am.
If she doesn't satisfy that basic requirement.
I doesn't belong to that area.
There will always say that I do not belong.
I'll take
it only. I think his documents will have the final say.
Correct. One of the issues that has been raised in the present appeal is about the place of residence of the appellant and whether it is within the jurisdiction of the Anganwadi Center at Vidyadarpur, Nuasahi. Correct?
Yes.
Counsel appearing for the state needs some time for instructions on this specific issue. At his request list on. There's no hurry. You're continuing.
As your lordship,
you must be continuing.
No, I'm not continuing. That is the issue.
He is not.
So your lordship may decide my fate. Your lordship may decide my fate. The only regret is some handful of individuals don't want I should continue, and I have been discontinued. That is the issue.
Anyway, only here that Anganwadi worker has become such a highly contested thing. So much litigation around that one post.
That's the previous one, my lord.
That a committee was constituted consisting of 7 members of lordship. I take
Only
that
to see whether she belongs to that village or not.
And whatever my land get, my lord, let him also serve a copy in advance so that
right. An affidavit to that effect be filed with an advance copy to consider the other side for the appellant and opposite party number
5.
7.
5.
5. All right. List on 9th May.
Obliged.
Item number 57.
My lord, in this case, the writ application was filed against the order of assessment of compensation under the Odisha Forest Contract Rules 1966, which is, in my opinion, not applicable for the alleged irregularities in cutting of bamboo in different forest divisions as labor contractor or raw material procurer appointed by the Odisha Forest Development Corporation after nationalization of bamboo forest in the state of Odisha under the provisions of the Odisha Forest Produce Control of Trade Act 1981. The present writ appeal has been filed against the order dated 19/4/2019 passed by the London single judge in OGC number 12860 of 1996, whereby the writ petition was dismissed on the ground that the London single judge has treated the petitioner as forest contractor, and in holding that the Odisha Forest Contract Rules 1966 applies. Even after coming into force of the Forest Produce Control of Trade Act 1981. The observation of the lone and single judge in holding that the petitioner as forest contractor should have hence have complied with the provisions of Rule 26 of the Odisha Forest Contract Rules 1966 is not correct, and the said observation is illegal. Kindly see Rule 3.1 of the Odisha Forest Contract Rules. Section 3.1.
Who's for the other side?
The matter actually
Odisha Forest Contract Rules 1966.
Bamboo forest in Odisha was being handled by the Odisha Forest Development Corporation since long, from 88. As per the
whom are you appearing for? OFDC.
I am OFDC. Government is has the demand. What happens? In the petitioner appellant for my lord was appointed as the forest.
No. I'm just asking who's appearing for whom.
I am from the corporation. Government is to support my demand.
All right.
Well, forest contract in the Forest Contract Rules 1966 has been defined. A forest contract means a contract whereby government agree to sell and purchase.
1 minute, sir. You say this definition itself, it does not satisfy. According to you, this definition itself is not satisfied.
Yes, because the sell and purchase has not been mentioned here. It is not for the purpose of sale and purchase of bamboos. It is only cutting rules. Cutting of extraction of bamboo for the agent appointed by the state government.
Why is bamboo not a forest produce? Bamboo is a forest produce.
That is Forest Contract Rules 1966, which was not applicable at present because of the 81 Act, Forest Produce Control of Trade Act. My lord, may see next one, forest contractor means the person who purchases produce under the forest contract. Therefore, sell and purchase ingredients in my case are not available. Therefore,
what is the stand of the government? Who is Mr. Bharti?
Yes, madam.
What is the stand? Was the counter filed in the writ petition?
No, my lord, may kindly see page 19 of the impugned order, running page 19. Now coming to the rule referred to in the writ petition and applicability of which is challenged by the petitioner, this quote from the definition of 3.2 defines the forest contractor, which means the person who purchases produce under a forest contract. This quote therefore is of the view that the petitioner is a forest contract in terms of the provisions of Rule 3.2 of the forest contract rules.
No, but is there a forest contract? I don't think there is. That's what he's been trying to, he's at pains to point out. There is no forest contract.
Yes.
But the status of the petitioner is a forest contractor.
No, but it has to be under a forest contract.
Yes.
Just see the definition, sir. Unless the contract is, there is a forest contract, there's no question of forest contractor.
The next Rule 26 has also been discussed in page 20. Now coming to the applicability of provision of Rule 26 of the Forest Contract Rules 1960, which my learned senior is now relying upon. This court finds Rule 26 of the rules reads as follows.
No, it begs the question, sir. Was there a forest contract is a question? Then we'll have forest contractor. Then we'll have Rule 26.
And the nature of work which the petitioner is undertaking.
No, there has to be a forest contract, sir. Only then all these provisions get attractive.
There is no counter filed.
No, there is counter in the writ petition. There is. You have the writ petition or you don't?
OFDC has filed the counter affidavit.
No, you also have filed.
Yes.
Have you got the writ petition copy?
That is not there. Let me bring that.
All right.
Lordship, next week I will
get the Mr. Mohanty, learned additional government advocate, requires time to study the writ petition pleadings in which the state government has filed its counter affidavit and then address arguments in the present appeal. That is request list of. We'll have it soon after the openings. 22nd June. 22nd June.
Item 58.
58, state appeal. The noting is that the notice could not be served on the respondent.
Address insufficient.
Address is, but we filed requisites on the basis of the address supplied by the respondent in the writ petition. So, if your lordship will say again, we will file the requisites, but without service of copy, this appeal cannot be heard.
No, you want to take out substituted service?
Then your lordship may substitute.
All right. The notice to respondents 1 and 2 has been returned undelivered with the report single quotes address insufficient. They must be your employees, no?
Yes. Employee and what the petitioner has given in the writ petition, the address, in that address we had issued the notice. They are both are husband and wife. Village Murtunga, PS Simulia, District Baleswar. Should I serve a copy to
What was the value of these materials? I'm just trying to wonder because this is an incident of 1999. You still want to prosecute all this? There's no need. Some confiscation of some material, forest material of 1999. What's the point in going after these people at this stage, sir? One husband and wife.
This address is given by them only in the writ petition. Your lordship can see the impugned order annexure 8 at page 62. This is the address they have provided in the writ petition, and accordingly we have filed the requisites.
So this is about release of a truck, right?
Yes, madam.
So by now the truck must have been released.
That is also
because
by the impugned order it must have been, because there is no stay.
Yeah. So what's the point, sir? You say, considering that this is an incident of 1999, and further considering that the impugned order was passed by the learned single judge on 12th April 2019. And with there being no stay of such order, the court does not see any good reason to interfere at the present stage in a writ appeal. In terms of the impugned order, a vehicle belonging to the respondents is supposed to have been released to them. Stop. With there being no stay, that order must have been implemented by now. Paragraph. In the circumstances, clarifying that the impugned order will not constitute a precedent, as it is passed in the peculiar facts of the case, the court declines to interfere. The writ appeal is disposed of.
May I pray that lordship may direct communication of this order to the assistant for compliance assistant. Otherwise, if the truck is not yet, they will immediately release it. Your lordship can say that if the truck is not yet released.
In the event that the truck has not yet been released to the respondents 1 and 2, it shall be released immediately.
Yes, ma'am. Assistant Conservator of Forest.
By the Assistant Conservator of Forests.
Divisional Office of the DFO Baripada Division.
Office of the DFO Baripada. All right.
Order 59. Order may be communicated.
Right. Order will be communicated to the said authority. Forthwith.
May I pray, your lordship? Well, here I have challenged the order of the Honorable Single Judge.
That R6 affixed on his house.
What has happened, my lord?
No, 1 minute. Who's R6?
R6.
Gopal Chandra Behra. Has everybody else been served? What's the position?
Look, some of them has appeared, former respondent, my lord.
Status quo is already there in your favor.
Yes, my lord. It can be disposed of, my lord. What has happened in 1978, consolation operation was initiated in the village Putiban, where the present appellant are the residents, my lord. And in 1984, the ROR and the map was finalized.
No. Are they all necessary parties? They've all been served? This is the question.
They were the petitioner in the...
No. Have they been properly served, sir?
Yes, my lord.
How do you know?
Because some of them has appeared through another council, ma'am.
No, sir. Just read this. This is 812 of 2020, right?
812-2020.
Notice issued to R3 return unserved. Notice to R6 returned with the remark that notice has been affixed on the dwelling house.
So we'll take a fresh notice.
All right.
Otherwise also they were
still unserved, and on R6 notice has been served through affixation on his dwelling house. None appears for either of them today. Fresh notice to R3.
Can you have a glance to order dated 20 January 2021? Learned advocate, the additional government has been undertaken to...
No, not like that. So these are private parties.
These are private parties. They were the petitioner in the writ petition.
That may be that. Fresh notice to opposite party numbers. Actually, 3 is Director of Consolidation.
Yes, madam.
You're not able to serve Director of Consolidation, Orissa, Bhubaneswar. Fresh notice to opposite party number 3, respond number 3. Returnable. Just keep this. 18 July.
Status quo to continue.
Yeah.
Item number 60.
Number 60, my lords. I am appearing on behalf of the sole respondent, my lord. Let them serve. I request, my lord, let them serve me a copy of the appeal, my lord. Matter can be
First day disposal.
No, fine.
Copy of the appeal paper book be served on counsel for the respondents. Interim order to continue. List on.
Notice has not been issued.
I see. Notice, he accepts notice.
And next step 3 to steady input order.
There shall be a stay of input order till the next day. List on. August 31st.
Item 61. Item number 61.
OPSC.
I have for state, my lord, OPSC has separate council.
All right, none appears dismissed.
I am appearing for respondent number 1.
All right.
Item 62.
Item 62, my lord. I am appearing on behalf of respondent, and your lordship in identical case, similar cases passed the order.
First day disposal.
Same, first day disposal. Just change the dates. It will be listed on 1st May.
That's a 5 day disposal.
I know.
Rehabilitation.
Change the dates. On 1st May 23. State will file its not later than 24th April.
Pardon, my lord. Weekly 23, the same matter.
Weekly 23.
My lord.
All right, same date. Weekly 23.
Item 63.
63 also same day.
Okay. All right.
Item 64.
Served or not?
Yes, my lord. Yeah, 64, your lordship may see, this is also rehabilitation assistance scheme. First, the disposal, what has happened, your lordship may see page 42 in the input order. That the Honorable Court has directed to consider his case in accordance with 2020 rule, but he has applied in pursuant to that 2020 rule, my lord. I have annexed his application, your lordship can find it from page.
Service, what about the
Sorry.
notice was that issue? What happened? Duly served. Correct. Despite service of notice, none appears for the respondent. The same was the position of the previous date, that is 14 December 2022. Paragraph. The challenge by the state in this writ appeal is to an order dated 5th August 2021 passed by the learned single judge, disposing of writ petition civil 22243 of 2021. The issue decided was regarding the rehabilitation assistance scheme and the date and which policy and whether the policy existed at the time of death of the government employee would apply or that at the time of the consideration of the application. So this issue is pending for a larger bench of the Supreme Court. And accordingly, the present appeal is adjourned sine die, awaiting the decision of the Supreme Court. Full stop. It will be open to the appellant to mention the matter for listing thereafter. The interim order passed by this court on 19th October 2022 is made absolute during the pendency of the present appeal. IA number 2786 of 2022 is disposed of.
65.
65, same. 65, 66.
No, same meaning, same as what?
Yes, ma'am. 65, 66 and 67 all are same.
No, same meaning rehabilitation assistance.
Rehabilitation.
67, my lord, I am appearing for respondent. I have filed my Bakalatnama. I'm in virtual mode.
But it's all gone for a larger bench of the Supreme Court, sir.
So here the facts are something different, your lordship. I will present before your lordship. Lordship, keep it 2 weeks after. I will file a written detail.
No, all this rehabilitation assistance, the same point, sir. Same point. Yes.
Item 68.
I am appealing for the opposite parties. Regarding double tax avoidance agreement.
This will take time because...
No, it is not taking time, my lords. The department has no case. It is the settled law. DTAA will prevail over the act. I will just draw you. I am assisting my learned.
It is accepted. No.
Yes, I am assisting my learned senior standing.
That is accepted. That is
yes.
That is
para 6 of the CIT appeals order may kindly be perused. It is a matter of 2008, my lords, this appeal. Para 6 of the CIT appeals order. Now the assessing officer treats it as a business income and taxed it under section 115A and read with section 44D. And therefore, following the judgment, your lordship's judgment, and also that Azadi Bachao Andolan, that double taxation agreement will always prevail.
Yes, that is not disputed.
Yes, I
admit that. I am not disputing that. That is not settled principle. That a law.
So therefore, para 6 may kindly be seen, my lords, of the appellate order. Para 6.
No, but questions have not been.
Yes. No. Questions have not been notice.
Question here is not the percentage of tax, whether 20% or 15%.
That is up to because of clause 12 of the year, they agree. It will not exceed 15%. How can you charge it at a rate of 20%?
And if it is not gross received, if its percentage is calculated, then why deduction, Lord?
That is,
you yourself have treated it as a business income.
Therefore, my lord, the question will be framed. Your lordship is on that day. Your lordship putting that question. Only DDA will. I say, my lord, it is yes. My lord, DDA will.
Your lordship's judgment is there
Yes,
in Delhi High Court, and also very recently, Supreme Court has also held 3 judges bench. Para 31 and 32. I am giving a judgment to you.
No, I am not disputing that. Why should you give judgment?
Yes.
That is a settled principle law. Everybody knows.
Okay, I beg apology.
No, I beg apology. Why should you, sir?
No, let's frame a question, I think.
But you are senior standing counsel.
So we'll frame the question.
Yes,
Which question to be framed?
Running page 3, question number A and B, my lord.
1 and 2, sir.
1 and 2. Sorry, 1 and 2.
I think only 2.
Only 2, my lord, but deduction is there, my lord. If it is gross issue, your lordship, no. When there is a gross issue, no deduction should be allowed.
1 and 2, my lords.
1 and 2.
All right. Admit the following questions are framed. 1 and 2 from page 3. List for hearing on this case.
Much appreciated.
My lords, your lordship is listing it.
For hearing?
For hearing, my lords, it is a 2008 matter, my lords.
2003 matter are there. You are taking time.
No, I am not taking time. You have taken time.
19th April.
19th April, my lords.
Yes.
Item 69.
69, my lords, I cannot say anything. My learned friend, senior standing counsel, Sunil Mishra said that India First Hour said that he will take time. Later on, after this said, yes. Said, I will do it. I said, all right, you do it. I'll agree to whatever you say.
It is your case. Please argue.
I'm not seeing my lords.
Your lordship, it is covered. Your lordship, so far as this issue is concerned, your lordship has already passed the order.
I am afraid of his voice. The voice he argues, my lords, really, my heart thrills.
Your lordship, it is that SDP
open sacks and fabric, my lords.
It is, your lordship has passed the
what
order.
I pray with your lordship's kind permission, my lords, since your lordship have
He'll
placed
get you a cup of tea, sir, today.
Huh?
He'll get you a cup of tea.
His voice is, my lords, very chilling. So therefore, my lords, I'll request, I am not equipped today to hear this voice. On 17th April, lordship will place it. Same order.
This is the for the assessment year 2003-4.
Correct.
Your lordship, so far as the 2000 assessment period 2003-4, there were 2 entries.
Right.
One entry is that packing material. Another entry is that 138 entry is that SDP, open sacks, SDP, PP, your lordship, all the SDP fabrics, your lordship.
Correct.
So your lordship, in this case, your lordship has considered that this
8%. It is
8%. Now, your lordship, it is for the prior period. In this case, in both the cases, your lordship, the period is 98-99, your lordship. So far as this 98-99 period, that 138 has been amended with effect from 1/0/2002. So, your lordship, here the petitioner's case is that the petitioner submission is that this is exempted as cloth. But your lordship, as per entry 22 of the tax-free schedule, his argument is that it is exempted. But your lordship, entry 22 is not attracted, your lordship, so far as the exemption is not attracted. It is that 138 attracted, but entry 138 has been amended with effect from 1/4/2002. For that reason, your lordship, the assessing officer as well as all the forums below have taxed it at unspecified goods, your lordship. It is, your lordship may kindly turn to.
So questions have to be framed.
Questions have been framed.
My lords, may I draw your lordship's kind attention to a judgment of this honorable court?
No, it's framed. Yes.
Your lordship, framed.
Yes.
Your lordship may kindly turn to that entry 136.
May I, at this stage, with your lordship's kind permission, I will draw your lordship's kind attention to a judgment of this very same issue, which has been dealt by this honorable court on 4/12/2018 I'll just give. Where, my lords, the full bench of the sales tax tribunal earlier gave a judgment in the favor of the dealer. Later on, my lords, the sales tax officer did not follow it, the judgment. So therefore, my lords, lordship will see has disregarded the order of the Orissa Sales Tax Tribunal Cuttack and has tried to distinguish the order of the tribunal. Yes, just a minute, wait. My case, relevant portion of the order of the sales tax officer is reproduced below.
No, that's a different thing, sir. That's a different thing. Because here the question framed is whether the full bench itself is correct or not. So that this will not apply. Here they did not follow the full bench.
Correct, ma'am.
Whereas the question here is whether the full bench is right or not.
So let's say entry 136. Your Lordship, prior to amendment, Your Lordship may kindly turn to entry 136 of the list.
No, we'll take it at the end of the board or what? We'll just finish.
My lords, may I pray, my lords?
5 minutes.
Can it be some other 5 minutes or 2 hours?
It is covered.
I'll say 1 hour. It is not covered.
Only why I'm arguing? Only
Tiny lower your voice. My lords, may I request your lordship with kind permission? Can it be any day next week?
Your Lordship, the last occasion it has been listed by Lord Senior has taken adjournment. Your Lordship, I need not argue any issue, Your Lordship.
Yes.
Why I'm arguing? Because it is the prior period, so only factual position.
May I just make my lords
only
with the lordship's kind permission, with the kind permission of the learned standing counsel, my lords, I pray, my lords, the matter to be listed at least next week, my lords, so that what he argued, let me check up and I'll submit, my lords. This, I think, will not prevent the learned standing counsel for a short adjournment. If it is covered, it's very well. It is to your pocket.
My Lord Senior.
He said he has taken 40 rupees.
The same petitioner, Your Lordship. And for a different period, Your Lordship has already decided. And this is the prior period.
Let us see.
Oh, it is 130.
Why you are so much shouting? Huh? For an adjournment, you are so miser.
They are contending it's exempt under entry 22.
Yes.
Oh.
Our contention is that it is 12%. It has been taxed at the rate of 12%. Since at that point of time, why I am showing this? Because Your Lordship has already determined 8% as per entry 136. 136 has been amended, substituted with effect from 1/3/2002. Prior to 1/3/2002, this entry was only plastic goods. Hence, these goods has been taxed as unspecified goods at the rate of 12%. So this is the point. And already Your Lordship has decided that it cannot be in 134 or it cannot be 4%, neither exempted nor 4%. Your Lordship has already decided. This is the issue, Your Lordship.
Well, let's see how his voice coming on.
No, both will be satisfied now. You say, Mr. Sunil Mishra, learned standing counsel, points out that for the subsequent period 2003-04, the issue stands answered in favor of the department with the decision dated 20 July 2021 of this court in STREV 1 of 2021, bracket Messrs. Taratani, Rubber India Private Limited, versus State of Orissa. He points out that inasmuch as the present petition pertains to the prior period 1999-2000.
98-99.
That 1998-99. The present petition also has to be decided likewise with the full stop. The only change according to him is that the relevant entry would be the residual entry.
Your Lordship, that is the entry 189, I think.
139. Since
Your Lordship, 189.
189. since entry 136, which was interpreted in the above decision, was amended with effect from 1st March 2002.
Your Lordship, it has been substituted 1/3/2002.
Yeah. Whereas this is a prior period paragraph. Mr. Siddharth Rai, and the senior counsel, states that he would like to examine the said judgment insofar as its applicability in the present case is concerned. At his request, list on 17th April. All right.
His voice is creating panic, my lords.
Your Lordship can consider my lord.
I have to bring
My lord and senior's voice is more louder than me.
You may have got a cup of tea, now you will not.
Much obliged.
All right.
Item 70.
Not in item 70. Not item 70,
I am
the
happy.
last order, let me kindly see. The Pollution Control Board authorities, they were directed to give a report.
The report has been submitted. And
I have already submitted report on 3rd, my lord. Though it is not reflected in the list, my lord, probably it has come, my lord.
So today, actually, they have filed an affidavit. The Lordship looks at.
Your Lordship directed that
affidavit along with the report they have submitted.
to take help of the other experts also, the representative of the CDMO office and also the...
Your Lordship may remember there is an interim order of status quo. We had filed an application for vacation of the status quo order and they objected it. And while deciding that IA, Your Lordship has passed the last order that Pollution Control Board will undertake an
This
investigation.
copy has been given to me just now. So I need to go through it actually, if Your Lordship can.
All right. You see,
Your Lordship, have a view on that report. All the allegations made by the petitioner are found to be wrong. And
Absolutely not correct.
It is absolutely correct, my lord.
With due respect,
whatever he has said in the writ petition, the Pollution Control Board has
and we'll let him examine it, sir.
a short date may be fixed because there are seven today. Your Lordship may kindly imagine.
Let the Honorable Court fix a short date. My lord.
Next Thursday.
The court has been handed over an additional counter affidavit today on behalf of the State Pollution Control Board Orissa with an advance
number
copy
6, madam.
to learn its senior counsel for the petitioner, who seeks a short adjournment to examine it and make submissions. List on. April.
Interim order to continue.
10th
interim order, yeah.
Lordship may fix it in March because this is the revenue month is going to be expired in 31st March. We have already all the we have already
exact
all the
she passed the other
auction.
All the other day, to one side the affected persons, the other side the residue. Which
there is absolutely no. That is the report of the SPCB. There is no house crack. There is no health hazard. Nothing. It is clearly reported. CDMO has visited. Our collector had visited. Everybody. And by virtue of the interim order, we are unable to settle.
These kind of matters, what does 31st March to do?
Query has to be settled. Accordingly, we have to collect the revenue. There are 7 queries.
Blasting the mountains.
All right. So 10th April is fine.
But interim order to continue.
Interim order to continue.
Supplementary list passed on matter item number 27. IA for dispensary I have already filed. Here, Milord, the question is not in internal page 6. Milord, the deduction of the amount which was not ascertainable in the accounting year, whether the admissible deduction or not. Milord, the tribunal has passed the order relying upon a decision of this tribunal, Milord, page 12. Lord, I have requested my department to submit what is the status of that.
All
It was
right.
not able to get that back.
All right. At the request of counsel for the appellant who wants time to find the status of
Lord, I'm just
appeal, if any, filed against the decision referred to by the tribunal.
Yes.
In the impugned order.
Yes.
Stop. 20th April. Sir.
Much appreciated.
We call out someone.
Weekly list. Fresh admission item number 1.
Item 1, my lord. On behalf of Mr. S. Patnaik, pray for next week, my lord.
Is anyone ready then? This whole drama will... Is anyone ready? Any matter? No. Is anyone ready to argue, or you're going to step forward to seek adjournment? If somebody is ready to argue, you tell us. If you're only going to ask for adjournment.
Item number 2, I'm ready, ma'am.
Item number 2.
Who's for the respondent?
This press admission. This press admission, not respect.
Fresh admission. Why,
notice has not issued.
Why is fresh admission put in weekly list?
May it please, ma'am.
Very strange. Even item 1 was fresh matter. Why would they put in the weekly? From which is fresh matters are not supposed to go to a weekly list.
My lord.
We'll spread it over now. We'll tell them to spread it over. I didn't know that fresh matters were being put in the list. It will come up next week, but it'll get spread over.
My lord. Obliged.